The Clerk will now proceed to read the orders of the day.
House of Lords Hereditary Peers Bill Committee.
Now.
Order. Order.
House of Lords Hereditary Peers Bill.
Debate will take place on the proposition that Clause 1 stand part, together with other clause stand part questions, and the amendments and new clauses that have been selected and are grouped together. May I remind members that in committee, members should not address the Chair as Deputy Speaker. Please use our names when addressing the Chair. Madam Chair, Chair or Madam Chairman are also acceptable. The question is that Clause 1 stand part of the bill. I call Minister Ellie Reeves.
Thank you, Madam Chair, and it's a pleasure to serve under your chairship as I open this committee of the whole House. As I noted a number of times during the second reading debate, this is a short and focused bill. It delivers on the Government's manifesto commitment to bring about an immediate reform by removing the right of the remaining hereditary peers to sit and vote in the House of Lords. This bill is a matter of principle. In the 21st century, it cannot be right for there to be places in our legislature reserved for those born into certain families. Having now seen all of the amendments tabled by parties from across the House, it is clear there is no principled objection to the aim of this bill, which is to remove the right of people to sit and make laws in our legislature by virtue of an accident of birth. Therefore, I would hope that all members across this House can join me and members on these benches voting for this important and long overdue legislation. Madam Chair, I look forward to hearing from honourable members over the course of today's debate, but I'll start with turning to the detail of the bill itself. Clause 1 is clear, straightforward and central to the overall purpose of this bill. It removes membership of the House of Lords from the remaining hereditary peers. Specifically, Clause 1 repeals Section 2 of the House of Lords Act 1999, which currently provides an exception to the general exclusion of hereditary peers from membership of the House in Section 1 of the 1999 Act. Under this exception, 90 hereditary peers and those hereditary peers holding the offices of Earl Marshal or performing the office of Lord Great Chamberlain continue to be members of the other place. Madam Chair, the clause is a core part of the bill and delivers the Government's clear manifesto commitment to remove the right of the remaining hereditary peers to sit and vote in the other place. This clause will result in the removal of the 92 reserved places for hereditary peers. There are currently vacancies in the seats reserved for hereditary peers. At present, there are therefore 88 hereditary peers in the other place. Such vacancies would usually be filled via a hereditary peer by-election. However, such by-elections have been paused until January 2026 by changes to the standing orders agreed by the other place in July 2024. Madam Chair, the Government values the good work done by hereditary peers, and we have spoken on several occasions about the individuals who have served in Parliament with duty and dedication. These reforms are not personal, but they are long overdue and essential.
I think the Government would find considerable sympathy for its position if it were to make provision for those hereditary peers currently in the House of Lords who have done good work, who have acquired a lot of experience, both in terms then of possibly a phase-out or a generous allocation of life peerages to those who are considered worthy on the basis of their past record of participation.
Minister.
I thank the honourable member for that intervention, and of course there would be no bar on the Leader of the Opposition nominating any of those who have served as hereditary peers for life peerages in the normal way. Clause 2 abolishes...
that sounds reasonable, except for the fact that obviously, unless there was a phasing of this process, it wouldn't be possible within the numbers available to the leaders of the opposition to nominate more than a small fraction. So can she offer any more flexibility on the point?
I thank the honourable gentleman for that intervention, but with the greatest respect, it is for the Leader of the Opposition to nominate those that they consider appropriate for life peerages. And just to say something about phasing out, the measures in the 99 Act were only meant to be as temporary measures. 25 years later, we are still having these debates. Clause 2 abolishes the jurisdiction of the House of Lords in relation to hereditary peerage claims. Madam Chair, I appreciate that the subject of hereditary peerage claims may be a novel one to honourable members and one that was not discussed at the Bill's second reading. Therefore, let me provide a clear explanation of what hereditary peerage claims are, why they are mentioned in the Bill and why the Government is proposing to remove the jurisdiction of the House of Lords. A hereditary peerage claim, or peerage claim as I will refer to them, is when a person seeks to be formally recognised as the holder of the title of a hereditary peerage. Usually the claimant of the peerage is the undisputed heir and is simply entered on the roll of peerage following an application to the Lord Chancellor. However, there can be some cases where the claim is disputed or complex. Currently, these cases are usually referred to the other place to advise the Crown on how to determine the claim. The House also confirms undisputed successions of Irish peerages in parallel with an application to the Lord Chancellor. Complex or disputed peerage claims occur very infrequently. There have been fewer than 10 claims considered by the other place in the last 50 years. Given that the Bill removes the final link between hereditary peerage and membership of the House of Lords, it is no longer appropriate for these issues to be dealt with by the other place. This is why the Bill seeks to abolish the jurisdiction of the other place in relation to peerage claims. The intention is that future complex or disputed peerage claims that would otherwise have been considered by the other place will instead be referred to the Judicial Committee of the Privy Council under Section 4 of the Judicial Committee Act 1833. Undisputed successions to Irish peerages will, like other types of peerage, continue to be dealt with by the Lord Chancellor. As honourable members know, the Judicial Committee of the Privy Council, which is made up of justices of the Supreme Court and other senior judges, already has a well-established constitutional role in advising the Sovereign and is the appropriate body to consider these matters. The Government has discussed this matter with the Judicial Committee of the Privy Council, who are content to take on this function. Therefore, the Government believes that following the removal of the hereditary peers, it is appropriate for the other place's jurisdiction in relation to peerage claims to come to an end. I thought it would be helpful to briefly address the amendment to this clause tabled by the Honourable Member for Brentwood and Ongar. This amendment seeks to make explicit that the jurisdiction for considering peerage claims would be transferred to the Judicial Committee of the Privy Council. The Government's position is that it is unnecessary to expressly state the transfer of the jurisdiction of peerage claims on the face of the Bill. This is because, as I have set out, matters such as peerage claims can already be referred to the Judicial Committee of the Privy Council by the Crown under Section 4 of the Judicial Committee Act 1833. I therefore urge the Honourable Member not to press this amendment. Turning to other parts of the Bill, Clause 3 makes consequential amendments to reflect the repeal of Section 2 of the House of Lords Act 1999, and more generally on the basis that there will no longer be any members of the House by virtue of a hereditary peerage. The amendments reflect the fact that certain provisions in the Peerage Act 1963, the House of Lords Act 1999, the Constitutional Reform and Governance Act 2010 and the House of Lords Reform Act 2014 are now redundant as a result of this legislation. Clause 4 sets out the territorial extent of the Bill and when it will commence. An amendment or repeal made by the bill has the same extent as the provision amended or repealed. Subject to this, the bill extends to England and Wales, Scotland and Northern Ireland.
I'm ready for giving way. There are those who believe that this reform of the House of Lords is about making it more democratic. Clearly she can't be amongst them because these provisions don't, it seems to me, make it any more democratic in any meaningful way. So she can confirm that she's not in favour of a more democratically elected House of Lords.
This legislation is the first step of reform of the House of Lords as set out in our manifesto. In our manifesto, we're committed to this reform immediately, and that's why we are here discussing it today. In terms of commencement, the bill will come into force at the end of the session of Parliament in which it receives royal assent. This means that if the bill passes in this session, hereditary peers who are members of the other place will depart at the end of the session. The timing of the implementation of the bill ensures the delivery of the manifesto commitment for immediate reform in a timely fashion whilst not undermining the business of the House with the sudden departure of a number of hereditary peers in the middle of a parliamentary session.
So I thank the Right Honourable Lady for giving way. My Right Honourable friend sort of touched upon the point as to where she thinks that more legislation will be coming forward, and she proudly boasted about delivering on one of the manifesto commitments of Labour. When does she anticipate over the next 2, 3, 4 years that the other pieces of legislation are going to be forthcoming to deliver on the rest of the manifesto?
We've made clear this is the first step of reform. The other reforms set out in the manifesto are reforms that we were committed to, but it's important that there is proper consultation and that we take the time to make sure that those reforms are done in the right way, which is work that is ongoing. Subject to the timely progress of this bill, it will give due notice to existing hereditary peers, allowing for opportunities to give valedictory speeches, which is also consistent with the approach taken in the 1999 Act. Clause 5 simply... I'll give way one last time.
I'm very grateful. On the subject of the future reforms, does the Minister not accept that when we were discussing House of Lords reform in 1998-99, the hereditaries were retained as a temporary measure, and yet the Labour government never came forward with the second stage? So does she appreciate that there are many of us that are slightly cynical that you will ever bring forward any future stage, and perhaps the solution is to delay commencement until you bring forward those proposals?
Well, those on the benches opposite had 14 years to bring around reform of the House of Lords if that was what they wanted to do, but alas not. Instead, this government is taking an immediate first step on the road to reform of the House of Lords. It is long overdue and we are getting on with it. Madam Chair, Clause 5 simply establishes the short title of Bill as the House of Lords Hereditary Peers Act 2024. If the bill is passed in 2025, then the short title of the bill will automatically be changed to the House of Lords Hereditary Peers Act 2025. Madam Chair, I note there have been a number of new clauses tabled to be included in the bill. Of course, I look forward to hearing from the newest and zealous member to the cause of constitutional reform, the Right Honourable Member for Stone, Great Wyrley and Penkridge, as well as the Honourable Member for Richmond Park, the Honourable Member for Perth and Kinross-shire and other Honourable Members. I'll not prejudge what they have to say on these matters, but I would note again that this is a focused bill which delivers on a clear manifesto commitment. As I've said, this is the first step in the government's broader plans to reform the second chamber. We recognise other elements of that agenda more complex, and it is right that we take time to consider them properly. Give way.
I'm grateful for the Right Honourable Lady for giving way. Would she be able to confirm why the government is proceeding with such timidity and first steps when it has such a large majority and could push through its will if it wanted?
This is an immediate first step on the road to wider reform, and one that is long overdue since the 1999 Act. It is right that we are getting on with it, and getting on with it in the first session of this Parliament. I'll give way.
Thank you, but the Honourable Lady has tried to paint the party opposite as a great reforming party, yet in 2012, when there was an opportunity to reform the House of Lords systematically, they voted against it. And I just wonder why the Honourable Lady is so scared to take on more bold suggestions to deliver her manifesto.
Exactly, yes.
Previous attempts to reform the other place, when it's been done all in one go, have failed. We want to see immediate reform to the other place, which is why we are getting on with this straight away, an immediate reform, and then we can engage and consult about how best to deliver the other reforms which we have set out clearly in our manifesto. And alongside this bill, the leader of the House of Lords is engaging in dialogue with the other place on taking forward reforms to bring about a smaller and more active second chamber. And in fact, as we speak, she is leading a debate on this very subject in the other place. And I look forward to further discussions on this matter in the House in due course so that we get it right. But none of the amendments tabled or debated contest the objective of this bill, to remove the right of people to sit and make laws in our legislature by virtue of an accident of birth. They should therefore not prevent us in making progress on this important and long overdue reform.
I call Shadow Minister Alex Burghart.
Thank you very much, Madam Chair. It's an honour to be able to talk to the committee stage of this bill. I mean, when we last discussed this bill at second reading, my right honourable friend, the member for Hertsmere, a very great man, set out why we on these benches do not approve of the way that the government is going about this. And we believe that this nervous little bill is misconceived and perhaps at its worst is dishonest. And it's been very good, as my right honourable friend for Holland and the Deepings said, to see that the Labour Party has finally rejected the idea of a democratically elected upper house. Always a bad idea, always something that was going to impose upon the primacy of this place. And, after the better part of a century of toing and froing on the issue, at last we see the Labour Party put that bad idea to bed. However, it has other bad ideas for us. And what we see here today is really an attempt to gerrymander the membership of the House of Lords under cover of a reform. New Clause 20 in my name allows us to call the bill out for what it is. We would like the government's failure to bring forward a proper plan for House of Lords reform, as promised in their manifesto, recorded in black and white as part of this bill. We would like the true purpose of this bill to enable, for the first time, all Lords temporal to be appointed by the Prime Minister to be placed on the face of the bill. Now, why does this matter? Well, nobody sits in the House of Lords now by simple right of birth. Before 1999, a hereditary peerage generally carried with it the right to sit and vote in the House of Lords. But the House of Lords Act in 1999 removed the right of most hereditary peers to membership of the House of Lords. Now, as we on this side of the House know, Labour has problematic relationship with history, and it seems to have forgotten that the reason why 90 hereditary peers were left was as a marker, a firm marker, for further reform. The idea being that there would be no more piecemeal reform of the House of Lords, but instead a government would need to bring forward a comprehensive plan for change. The Labour government is now, of course, asserting that the continued presence of accepted hereditary peers is an accident. This is not true. At the time, Lord Irvine of Legg explained that the hereditary peers remained as a guarantee from the Labour government that the second stage or proper reform of the House of Lords would take place. As he put it in 1998, A compromise in these terms would guarantee that Stage 2 would take place, because the government, with their great popular majority and their manifesto pledge, would not tolerate 10% of the hereditary peerage remaining for long. But I will just finish this quotation from Lord Irvine of Legg, and then I will be right with him. It will not tolerate 10% of the hereditary peerage remaining for long, but the 10% will go only when Stage 2 has taken place, so it is a guarantee that it will take place. That lifetime guarantee appears now to have expired. I'm happy to give way to my honourable friend.
I'm grateful. I'm a bit worried about what my honourable friend is saying. Why do we need a comprehensive plan at all? Why not just leave it alone? As that great Conservative Lord Falkland once said, when it is not necessary to do something, it's necessary not to do it.
As ever, my honourable friend is one step ahead of me, because it is not that we seek a comprehensive reform of the House of Lords, it's that the Labour Party promised that this would come, and they promised that they would leave the remaining hereditary peers there until they had a plan for comprehensive reform. This comprehensive plan is missing. Labour are throwing out the stone in the shoe of the accepted hereditary peers and dodging the hard principled questions about how to ensure the House of Lords functions most effectively. So this, with great pleasure.
I'm very grateful to my honourable friend. He did make a passing reference to a fear that what was going on here was a form of gerrymandering. Does he agree with me that if generous provision were to be made for those really active members, of whom there are probably quite a few of the remaining hereditaries, to be given life peerages on a one-off basis and on the basis of merit, that would dispose of the suspicion of gerrymandering?
Well, my right honourable friend is absolutely right, and I think he strikes at what is the critical failure of this legislation. And the critical failure is this, that what the government is really doing is seeking to remove members of the upper house who happen not to take the Labour whip. And what we all agree on, what we hope we all agree on in this place, is that the role of the Lords is as a chamber of scrutiny. And we must welcome more scrutiny, more expert scrutiny. And we've seen from the behaviour and attendance and the work that those hereditary peers have done that they are an intrinsic part of that scrutiny. So it is highly suspicious that the Labour Party should seek to remove them. And indeed, if we set the precedent here that a government of the day can remove members of one of the houses because they don't agree with them, well, where will that end? You know, those crossbencher hereditary peers who are going to be axed by this have, as far as I can see, done an excellent job, and yet they are not being given another way out, such as that suggested by my right honourable friend behind me. I'm happy to give way to this gentleman here.
I do think the Lord General for giving way. He will know that provisions under the 99 Act stipulate a specific number of hereditary peers by class, by category of political party affiliation. Would he not accept that the only place where a by-election is possible, where you can guarantee the party of the victor before any vote has been cast, was the House of Lords? And if he is worried about expertise in the House of Lords being lost through the hereditary peers being expelled, would he even acknowledge that should they stay, which I don't think they should, that the removal of that ring fence of particular protections for party political positions ought to be removed?
Shadow Minister.
My point is more that what the government is seeking to do is to remove some highly experienced people and not offer another way out. And that's something that we would have been very happy to debate in this place. Instead, what we're seeing is an attempt to deliberately cut out a group of peers from the Constitution. I think there was somebody who's trying to give way over here.
Thank you for giving way. I appreciate the Shadow Minister for giving way. I wondered if he would be clear about what his party's position was on the reform of the House of Lords, because we've heard 2 or 3 different views from that side of the chamber. And also I would remind him that actually, if we do feel that these hereditary peers are doing a good job, there is an opportunity for his leader to give them life peerages.
Shadow Minister.
Well, it's very generous of him to say that the Prime Minister is going to create 40 peers at his command. I had no idea that his career was progressing at such a rate. But we all know that that's not what's happening here. We all know that, in the coded words of the Shadow Minister, is that it's goodbye to these 88 hereditary peers, and that their voice will not be heard anymore. Our position is that we think it's time for a constitutional conference to look at these matters, but that the major issue is how we have an upper house that does not challenge the primacy of the Commons and can conduct proper scrutiny of government legislation in order to improve it. There was an intervention over here. No? OK, I will happily give way to the honourable gentleman behind me.
I'm immensely grateful to my honourable friend who's making a speech in the spirit of his predecessor, the Right Honourable Member for Hertsmere, on why this legislation doesn't pass the test I set it at the second reading of efficacy. There is no suggestion that this is going to make the House of Lords a more effective chamber, and it is a reasonable test of legislation. Does it improve the status quo? If it doesn't, why on earth are we pursuing it? Indeed, why are we even debating it?
Minister.
Well, as ever, Madam Chair, wisdom from the Deepings. The truth is that this will not make the upper house a better chamber for scrutiny. All it will do is remove some of the Labour Party's opponents from that house. Now, the Labour Party promised in its manifesto that the next Labour government will bring about an immediate modernisation of the Lords. And the manifesto promised this modernisation would consist of a mandatory retirement age of 80, a new participation requirement, a strengthening of the circumstances in which disgraced peers could be removed from the House, reform of the appointments process, and improvement in the national and regional balance of the second chamber. Now, we on these benches might not agree with those proposals, but the Labour Party promised to bring them forward immediately. And the only immediate modernisation being undertaken is to remove a group of hard-working, diligent peers from the other place, including 33 crossbench members and their convener, for the crime of not being Labour Party placements, who are happy to give way.
I'm very grateful for the Shadow Minister for giving way. As the so-called party of aspiration, I'm very surprised that the Conservative benches are defending stalwartly the principle of hereditary peers. Will they not accept that in a meritocracy, positions in the legislature should be open to merit, not inheritance?
So speaks.
You're defending my appointment only.
The point that we're making by these amendments is that the Labour Party is undermining one of the key facets of the upper house, which is scrutiny. And we're talking about a body of 88 hereditary peers who have already been performing that job, who have done nothing wrong, but are losing that job because of the measures being brought forward in this bill. I'll give way one more time to the honourable gentleman, and I will endeavour to...
I do thank the honourable gentleman for taking a second intervention. Is he suggesting in some way that life peers, and I declare an interest, Madam Chair, my partner is a life peer, is he honestly suggesting that life peers are unable to undertake the role of scrutiny? Because even with these modest reforms that are a stepping stone towards greater reform, my party will still be the third largest party in the House of Lords. His party will still be the largest party by some way. Is he honestly saying that his life peers are unable to take reform seriously?
No, I'm delighted to hear that the honourable gentleman is married so well. But of course, life peers can do a fantastic job of scrutiny. They do every day. I enjoy reading their lordships' Hansard. But what we're talking about is a group of 88 hereditary peers who have done a very good job in scrutinising government legislation and who are being removed through no fault of their own, but simply because they do not fit with the Labour Party's views. And we believe that that is wrong. I turn now to Amendment 25 in my name. This amendment is concerned with a very simple Conservative principle, that constitutional change should not be rushed, and certainly should not be proposed for political advantage. We have inherited a constitution that has evolved through the generations. It has the distinction of working. The current constitution of the other place has been effective in bringing expertise and a degree of independence to the work of legislative scrutiny. Like much of the uncodified British constitution, one might not have created such a system from scratch, but the tried and tested checks and balances of the House of Lords have complemented the work of the elected Commons. The Lords does not claim to be a democratic chamber, and that is the point. Our House has primacy. We can see through the dangers of ill-thought-through constitutional change. None of us in this place will forget the difficulties caused by the Fixed Term Parliament Act, that foolish measure that the coalition government brought in, which created all manner of unintended consequences. It was rightly repealed by the Conservatives in the last Parliament to reinstate tried and tested long-standing conventions. Let this be a warning to this government, in the name of petty politics, as they meddle around with long-standing conventions that are working. Walter Bagot eloquently described the dignified and efficient elements of our Constitution. In a sense, the hereditary peers represent both, due to the way they diligently scrutinise legislation. Labour must take care that pulling on one thread, in this case that of the hereditaries, does not unravel a great deal more. Amendment 25 seeks to ensure that there is proper scrutiny of the changes to the composition of our legislature. It makes a simple request. It is merely that a joint committee of both houses should be allowed to scrutinise the government's so-called immediate, so-called modernisation plans, to report on those plans, and for this place to agree before legislation comes into force. A plan led by the Conservative principle that constitutional change should not be rushed, but carefully considered, and only implemented if the House is confident that it will work. Amendment 26 in my name is seeking clarity on the issue of the disputed peerage claims, but I've listened carefully to what the Honourable lady said, the Minister said, and I understand that there are existing mechanisms in place, and for that reason we will not move it. To conclude, we on these benches think this bill is a sham of reform. It is fundamentally misconceived, focusing on the composition of the other place rather than how we can ensure the other place best performs its vital role of scrutiny. This is a government and a Prime Minister that does not stand up to scrutiny. It's led by politics, not by principles. My amendments seek to reinsert some principles into this process, that promises to both Parliament and the electorate should be kept, that we should only legislate for what works, not for political advantage, and I see no reason why the government cannot accept these amendments today.
I call Gareth Snell.
Thank you very much, Madam Chair. It's a pleasure to serve under your chairmanship. I'll keep my comments brief, because I know that will entertain the House more. I haven't started yet. Give me time. I very much enjoyed the second reading debate on this, Madam Chair, hence why I've come back for a second go. And I genuinely do welcome the honourable gentleman from Stone, Great Wyrley and Penkridge to his new reforming zeal. And I genuinely believe there are merits in some of the amendments to which his name is put today. I also, and I'm glad that the honourable gentleman from West Suffolk has said that they're part of our manifesto, because they are, as is this bill, which means I'm sure he will want to see the acceptance of the Salisbury Convention at the other end, at the other place, when this bill reaches them, and therefore there will be no attempts by members of the opposition party in the House of Lords to seek to prevent this bill from its successful passage. I'm sure at some point in today's proceedings one of the opposition front bench will be able to confirm that for the record, that it will pass smoothly once it has passed this House. We've just heard very eloquently from the honourable gentleman the importance of the primacy of this House. This House is going to make a decision on this bill today. It's going to decide whether or not we believe that there should be a role for hereditary peers in the House of Lords, and then that bill will be sent to the House of Lords, where I'm sure, given the importance of convention, the importance of history, the importance of statute, that the honourable gentleman will be able to confirm that the House of Lords will pass it happily without any attempts by opposition members to amend it. I doubt it, but I hope. The point of this bill today, and the reason why I think it does deserve support from all sides of the House, is, as was pointed out by my right honourable friend the Minister, this is the first step on a provision and a package of amendments, a package of reform that is going to the House of Lords. It is entirely clear, happily.
I'm extremely grateful to the honourable gentleman, and I think he's a serious individual on the government benches, and I respect him very much, but does he not understand that for such a delicate constitutional set of arrangements that we have, it's not unreasonable to expect the government to come forward with a plan with several steps set out, taking us on the journey that they intend to go on with some substance behind it. And that given the number of years they've had since the previous changes over a quarter of a century ago, it's not unreasonable to expect a little bit more detail on that second, third and fourth step, or a timetable therein.
I thank the honourable gentleman for that, and to a degree, I agree. And that is why, as was set out in our manifesto, the package of reforms and changes that we hope to see happen in this Parliament to the other place in order to deliver on the promises that we made in that election. And he's absolutely right when he says that constitutional reform is a delicate thing. And that is why it is important that we do these reforms with consideration in small steps to make sure that the unintended consequences of large-scale reform simply aren't felt. And he will know from the modest reforms that his party put through in the last Parliament around having an ability to retire from the House. Small, consequential, impactful changes that have led to far more members leaving the House of Lords under that provision than will be impacted by the provisions that are in this bill. But it is entirely because that was done thoughtfully, carefully, slowly, and I'm not sure. I think it was consensually, which I think there is. The principle of this bill has already been established. The right for the hereditary peers to no longer sit in the House of Lords, I think, has been established in this House. None of the amendments that are put forward today seek to overturn that. None of the amendments seek to make a case for the continuation of hereditary peers, Madam Chair. So I think that consensuality that the honourable gentleman so rightly talks about exists in this bill. The more we seek to tack onto the bill, the more we seek to take other elements of constitutional reform and add it to this bill today, risks the chance that consensus falls apart. It risks the fact that perhaps this House doesn't then have a settled position, and then gives opportunity for those potential wrecking amendments, none of which I would potentially suggest the members opposite are putting down, but wrecking amendments elsewhere to completely flatline what I think is a very modest and sensible reform. Yes, I'll give way.
The honourable gentleman is making a very reasonable speech, and would it be fair to say that what he's trying to get at is almost a case of going for the low-hanging fruit on which everybody has a measure of agreement, whilst recognising that future steps may be a lot more complex and potentially dangerous if we get them wrong. But there is one aspect which is not of itself an argument for keeping the hereditary peers, but which is something that will be lost if and when they go, and that is they are one group of people who are not appointed subject to prime ministerial patronage. And can he perhaps give us an inkling, without spreading beyond the scope of this debate today, as to whether or not something like putting the House of Lords Appointments Committee on a statutory basis is a reform that the government might consider, bearing in mind some of the controversial cases of people being imposed on the House of Lords in defiance of the committee's preferences?
Thank the honourable gentleman for that. I couldn't possibly begin to offer up an opinion as to the thoughts of the government, but I know that my honourable friends will have heard that question and will make it. I know when to move on. So let me say to the honourable gentleman but again, I would never dare call the hereditary peers low-hanging fruit, because I think that would be slightly disrespectful to them. But I understand the tenor and the tone of which he is saying, and I believe if he'll just allow me one moment to address the final point. I think he is right. This is about starting with something where there is broad consensus, where the impact on the other house will change our constitutional setup, but not in a way that is ultimately going to be detrimental to the important scrutiny role that the House of Lords has. I actually agree with him around the importance of the role of the House of Lords Advisory Committee and the robustness with which their advice should be taken. I think there is something to be said about, without wishing to go down the political point scoring role, there is something to be said about an independent verification of the individual suitability to that place and how that ought to be respected and put onto a footing that potentially means that instance that we have seen in previous iterations of the Prime Minister may not be allowed to occur again. Again, I would love to be able to make a commitment here, but the only thing I can commit to is things for my constituency and my own particular personal opinion. Did the honourable gentleman still seek?
I'm grateful to the member for giving way. He spoke about the need for consensus. I wonder if he'd read new clauses 1 and 2, which my honourable friend has tabled, which removes the bishops from the upper house. I'm sure that's something on which there's great agreement on benches opposite. Is that something, would he feel able to support new clauses 1 and 2?
Get rid of it.
So the honourable gentleman, I think, has highlighted exactly a great example where, on the face of it, there may seem to be consensus, but where I would fear the immediate consequential impact is not as simple as he thinks. We have an established church in this country. The Church of England is an established church. It's part of who we are. It's how we go. The removal of the bishops from the House of Lords, I fear, then opens up a whole series of other conversations about whether or not we still have an established church. It opens up, I believe, potentially questions about political and ecclesiastical overlay, which again, I think we should debate it. I think we should have time to debate and discuss and consider the role of the clergy and whether there's right to have bishops in the House of Lords. I do not see why it has to be done as a tacked-on amendment to this bill, but I do believe it's something we should be discussing in the future.
Thank you, Gavin, Williamson. Gentlemen, for giving way. And we don't usually have so much debate in Staffordshire on these matters, so it's nice to, and we usually have a lot of consensus in Staffordshire, but I really do want to clarify that the amendments that I'm seeking to put into this bill will not disestablish the Church of England, but what it will do is it will make sure that there's an anomaly removed from our constitutional arrangements, very much as the anomaly that this bill is attempting to remove.
I do thank the honourable gentleman for that, and he is right. This is probably more Staffordshire than anybody really needs to hear in this debate, so I will conclude my remarks momentarily. But again, I don't disagree with the necessary principle that he is putting forward of the right and whether or not the bishop should be entitled to seats in the House of Lords by virtue of being bishops. And obviously, there is a bill coming on Thursday that amends the rights of women bishops to sit in the House of Lords because we have always, over time, gently updated and amended our constitution to ensure that it reflects the society that we want to be. I would welcome an opportunity to properly debate and consider, and I know he says that it is not his intention to disestablish the Church of England by the removal of the bishops, but there are consequences to these actions which I think deserve more consideration and debate. More consideration and debate. Well, the honourable gentleman says, what are they? That is what we would have a debate for in the future. That is why we would have an opportunity to explore that. Today, having had a second reading debate, we go to committee stage of this bill to look at exclusively the responsibilities and role that hereditary peers play in our democracy. I'll give way to
Thank the honourable gentleman for giving way. Instead of saying we need to have a debate in the future about whether this might risk this disestablishment, can he actually just explain what he thinks that risk is? What are the legal and constitutional consequences that would risk disestablishing the church?
I think by the very nature of the fact that we would be seeking to expel the bishops, who are the representatives of the Church of England, from the national legislature, it would start a consideration of that process. And the honourable gentleman may say it doesn't, but he does not know that. I fear that a well-meaning amendment from the honourable gentleman from Stone, Great Wyrley, Penkridge and Cheslin Hay would in fact create a whole more significant debate around the role of the Church in our country. And whilst that is a debate we may want to have, I'm not sure it should be triggered on the back of an amendment to a very short, very tightly written bill around the role of hereditary peers in the House of Lords. And if the honourable gentleman wants to bring something forward, I would be more than happy to talk to him about how I could support that, but it shouldn't be something that is tacked onto a bill where there is already clear consensus around the role and the responsibilities of hereditary peers. And so that, Madam Deputy Speaker, I hope would deal, sorry, Madam Chair, would deal with the point that the honourable gentleman has made. And then finally, Madam Chair, the honourable, in the second reading debate, we heard lots about what this meant for our manifesto and what this meant for the Labour Party's commitment to House of Lords reform. The 99 reforms were one of the most significant changes to our constitutional settlement there had been for a very long time. It wasn't just about the expulsion of the hereditary peers, the creation of the Lord Speaker, the removal of the law laws to sit at the Supreme Court. It was a package over time that came forward in a series of bills to implement the commitment that we made at the 97 election. This, for me, Madam Chair, is the start of where we are today. We put the bill through that does the first part, we bank that and then we move on. I know there is now across the House an appetite for considerable reform of the House of Lords. That's been evident by the speeches from the members opposite. But what we need to do is bank what we have got, move forward, and that is why today I hope that we are able to pass this bill through committee stage, unamended and on to third reading, so it can make its way to the other place where, because of the commitment I know the Minister is going to give in summing up later on, that the Salisbury Convention will be engaged, that it can pass through the House of Lords quickly, without change, and we can move on with the rest of the reform that we require.
Yeah. I call the Liberal Democrat spokesperson, Sarah Olney.
Thank you, Madam Chair. I rise to speak in support of new clauses 7 and 8, tabled in my name, and their associated consequential amendments. And it's a pleasure to follow the member for Stoke-on-Trent Central, simply because I think in many parts of what he was saying actually very much supports my amendments. And certainly some of the points he made I am going to be making also. My Liberal Democrat colleagues and I are proud that it is our party that has for decades led the call for the reform of the House of Lords with a democratic mandate. And this bill is a welcome step forward and one which we support. However, we do believe that broader and bolder reform of our upper chamber is needed, which is why I have tabled these two amendments to extend the powers of this legislation. These amendments would finally see the House of Lords with a democratic mandate and would ensure that the House of Lords Appointment Commission can never again be sidestepped and ignored by an unscrupulous government. With pleasure.
I welcome her latter point about strengthening the House of Lords Appointments Commission. But although it's a risk of broadening the debate perhaps a little too far, can she explain why it would be a sensible idea to have a second chamber of elected parliamentarians, which would be rather like more than doubling the size of this House, but putting them in two separate places, possibly elected by different electoral systems and at different times? A recipe for deadlock and conflict. It's impossible to imagine more than this.
I thank the honourable gentleman for his intervention. I very much look forward to having that debate, and I very much look forward to when we will do that in a future session of this Parliament and a future piece of legislation, which is why I'm tabling this amendment today, to call on the government to make that commitment so that we can have that future legislation and we can debate what broader and further reforms we can support here in the House, in this House, to ensure the democratic legitimacy of the House of Lords. Very grateful, gentleman.
For giving way. Does you remember that, in fact, we have had that debate? We had it last in a proper sense in 2007 with Jack Straw's proposals at that time, and on the basis of the consensus that we are trying to establish here, consensus there was none, and the thing descended into complete chaos. So would you recall that when making her proposals, since I'm afraid if she hopes there will be consensus on this extremely difficult issue of an elected House of Lords, she's in cloud cuckoo land.
Yep. Well, how polite of the honourable gentleman to say so. Can I just say, obviously, I don't personally have any recall of what happened in 2007. What we are trying to establish today is that there are steps that can be taken to reform the House of Lords. We very much support this step that we are debating today as that first step, upon which, as the Minister said in her opening remarks, there is a broad consensus. So we support this step. What we want to see is broader reform of the House of Lords, and we want to see the government bring forward further proposals in due course, and my amendment today is about pushing them to produce those further proposals in a timely fashion, so that we can have that debate in this Parliament, and that we can progress the cause of what we can find consensus across the House for.
I'm extremely grateful, Johnny. And given her amendments, assuming they're not passed, I assume on the grounds of both logic and consistency, she will vote against the bill at third reading unamended. For as I said earlier, and as she implicitly conceded in her own remarks, as it stands, this bill doesn't make the House of Lords 1 ounce, 1 iota, 1 fraction more democratic.
I thank the honourable gentleman for his intervention. We intend to support this bill because we want to see the abolition of the hereditary peers. That is very much part of what the Liberal Democrats want to see. We want to see more. We want to go further. We want to see broader reforms. We would like, and I have to say to the honourable gentleman, I have heard from all sides so far that there is an appetite, firstly, to support this bill, as the Minister said. There is a broad consensus across the House for that, but also there is a great zeal on the Tory benches, I hear, for further reform, and so I don't understand why there wouldn't be broad support for my amendment, which calls upon the government to enshrine within this legislation a commitment to go further, which is clearly what I'm hearing from so many Tory members they would like to see. With so much trust in politics destroyed by the chaos of the last Conservative government, we must take this opportunity to underscore the integrity of Parliament with transparency and democratic authority in our second chamber. So we're grateful to the government for introducing this legislation so early in the Parliament. Fundamentally, the Liberal Democrats do not believe that there is space in a modern democracy for hereditary privilege. I firstly wish to speak in favour of new clause 7. This new clause would impose a duty on ministers to take forward proposals to secure a democratic mandate for the House of Lords through introduction of directly elected members. Across the world, trust in the institutions and levers of the democratic process have too often frayed over recent years. In our democracy, we must ensure that the vital link between the people and their institutions remains strong. A democratic mandate must be central to that mission. Reform of our upper chamber has been a long-standing Liberal Democrat policy. We must do all we can to restore public trust in politics after the chaos of the previous Conservative government. By introducing a democratic mandate for members of the House of Lords, we can ensure that trust in politics is strengthened. The disregard with which the last Conservative government treated the public's trust threatens to erode faith in our democracy. This is an opportunity to underline our commitment to democratic values, to begin to rebuild that trust. This amendment would strengthen the democratic mandate of the second chamber, and Liberal Democrats call for the government to support this, as well as our calls for wider electoral reform to modernise our electoral system. We want to strengthen democratic rights and participation by scrapping the Conservative Party's voter ID scheme, expanding... With pleasure.
I do thank the Honourable Lady. And I'm sure there's a lot that we can agree on across the House, and as the Honourable Lady has noticed, as I've tabled an amendment to remove the bishops, will her party be supporting that? Because traditionally it's certainly something, a policy that the Liberal Democrats had supported, and will they be supporting that today if it comes to a vote?
I thank the member for his intervention. I'm happy to say we do support that ambition long term. I don't believe that this piece of legislation that we are debating today is the correct vehicle for that. As was said by the Minister in her opening remarks, there is currently a widespread consensus on this piece of legislation, and I believe that trying to tack on the amendment that the Honourable Member for Stone, Great Wyrley and Penkridge has proposed would threaten its passage through the other place. And I want to see this bill, with the provisions that are currently enshrined within it, pass as quickly as possible. So we will not be supporting that amendment today. We want to take big money out of politics by capping donations to political parties. We want to see this new Labour government be bold in transferring greater powers away from Westminster and Whitehall. We believe that local authorities know best what their communities and towns need, and we want this government to acknowledge that by boosting their authority and powers. We continue to support the findings of the Burns report in 2017, which claims the House of Lords should be cut to 600 peers and outlines ways to ensure that this happens. And whilst the removal of hereditary members is an important step in this process, we will continue to push the government to continue with further reform in the future. In particular, we look to them to uphold their manifesto commitment of introducing a retirement age, a measure which further aids the reduction and subsequent management of the size and membership of the House. We want the second chamber to have proper democratic legitimacy, ultimately moving towards a replacement of the House of Lords with an elected chamber, and we believe that moving to a fully democratic elected chamber is essential in strengthening the integrity of Parliament and the authority of our second chamber. This new clause would enshrine a democratic mandate for our second chamber, strengthening the integrity of our Parliament. I also wish to speak in support of new clause 8. This new clause would prevent a life peerage being conferred on a person if the House of Lords Appointments Commission has recommended against the appointment. We have consistently spoken out against the current system of prime ministerial appointments, which ingrains patronage, reinforces the elitism of British politics and contributes to so many people losing faith in our system. We would like the government to reassure us that they will not be following in the footsteps of the former Conservative government who allowed the other house to balloon in size, and that they will do everything they are able to prevent a culture of sleaze and cronyism develop in their administration as we saw under the previous Conservative government. As former Prime Minister, Boris Johnson proved by becoming the first Prime Minister to ignore the advice of HOLAC, making deeply inappropriate appointments to the other house, it is far too easy for a culture of sleaze to develop in the heart of government. It's essential that we strengthen and improve public confidence in politics, and I hope the Minister will agree with me that in accepting this amendment, the integrity of any government will be strengthened and prevent this kind of behaviour from returning to Westminster. This amendment would ensure that recommendations made by the House of Lords Appointment Commission can no longer be bypassed by the Prime Minister, improving the integrity and democratic powers of our second chamber. I'm glad that the government has indicated that this legislation is a first step in reforming the other place, and that in their manifesto they committed to reforms, including changes to the appointment process. I'm also grateful to the Minister for his recent commitment to me that he would consider improving the mechanisms to review appointments to the other house, implementing safeguards to protect against cronyism. And if the Minister and the Prime Minister are sufficiently convinced that they will not ever override HOLAC, which they should be, then will they agree with me that enshrining that principle in law is a good thing? This new clause would strengthen the powers of the House of Lords Appointments Commission, and I urge the Minister to support it to balance the perception that the House of Lords will now be more subject to patronage, and I also ask him to set out a timeline of his intention to bring in these broader reforms, which would bring the appointment of peers more in line with those of other honours such as knighthoods, requiring an overview of relevant skills, knowledge and experience of the candidate. It's clear we're living in a new era of politics. Political engagement is at a historic low. Voter participation in our recent general election was the lowest since 2001, with fewer than 60% of eligible voters casting their ballot. It's vital that we do all we can to restore public trust in government. And it's also important that Parliament represents and reflects the diversity and richness of the people and cultures which make up our country. Currently, not a single one of our hereditary peers is a woman. The privilege of hereditary peers membership exacerbates the distinct gender imbalance of the second chamber. This legislation, removing the last remaining hereditary peers membership to the other place, is a significant step in moving towards a more representative Parliament. I hope we can all agree on the inappropriateness of hereditary status as a qualification for membership of a modern parliamentary democracy, that being the son, the grandson or the great-grandson of a former courtier, colonial administrator or 20th century businessman is neither reason nor justification for a seat in a democratic parliament. I and my Liberal Democrat colleagues therefore welcome this legislation, and we are grateful to the government that in this legislation and subsequently we hope to see the most significant modernisation of the upper chamber in a quarter of a century. Thank you, Madam Chair.
I call Mark Sewards.
Thank you very much, Madam Chair. I'm a proud elected member of this House. Like everyone in this place, I was sent here by my constituents to fulfil the greatest honour of my life for as long as the people of Leeds South West and Morley give me permission to do so. Now, I've heard the opposition frontbench state today that this bill is not based on principle, merely on political advantage. The truth is that serving in Westminster should never be an inalienable birthright. That is a basic principle that I think we can all get behind. Now, the very concept of hereditary peers remains indefensible in the 21st century. We are one of only 2 nations that currently has them. There should not be 92 reserved seats in the other place for people born into the correct families. I think it is time to end this now. Now, the bill not only sets out our ambition to remove this archaic right, it also shows our determination to make our democracy stronger and more representative. It is just the start of our commitment to reform the other place and improve its ability to do what we were all sent here to do, and that is serve the public. It's right that after this immediate start on hereditary peers, the government will take time to consider how best to implement further reforms with the public and peers heavily involved in those discussions. And given the enthusiasm on the benches opposite for the changes that might be coming, I look forward to seeing them leading the charge with us to reform the other place. Now, with that said, there has been some confusion on those benches opposite about their position during this bill. I did enjoy during the second reading that there were suggestions we were going too far, and I also enjoyed the suggestions that we weren't going far enough. They appear to want more debate on the broader changes that we are suggesting for the other place, but they spent their time in government blocking such changes in over a decade. Zero progress. I will happily give way to whichever is more enthusiastic.
I'm very grateful to the honourable gentleman and to my right honourable friend. He's made an argument that's based on the principle that hereditary peerages are wrong. Can he give us a clear argument in principle as to why he believes that a lifetime peerage should be acceptable and a part of our constitution in which those peers can legislate for an entire lifetime, for decades, without any kind of accountability at all?
Thank you. I'm very grateful to the honourable gentleman for his intervention. I would state that hereditary peers are there because they are born into that family. That cannot be right. Life peers are there because they are appointed, usually because of their expertise that they can offer during the scrutiny of legislation that passes through this place. So I would suggest that life peers definitely have the advantage over hereditary peers, simply because they're not there because of the family they were born into. I will give way.
So Gavin Williamson.
I thank the honourable member for his generosity in giving way. And I think he makes a very persuasive argument and a very strong argument. What right does he think that the Bishop of Winchester has to vote on matters to do with his constituents in Leeds South West and Morley and my constituents of Stone, Great Wyrley and Penkridge? What gives that bishop the right in order to be able to be a legislator? What's the argument?
That's a good question.
Sewards.
I'm grateful for his intervention, and I have read his amendment and I understand the arguments that he's making, but the changes we're proposing today are quite simply a down payment on the broader changes we will be bringing to the other place. And when we do bring those other changes forward, I look forward to marching side by side along with him through the eye chamber. Now, I would gently suggest that many of the problems in our country today have been made significantly worse because the Conservative Party have often prioritised keeping their factions happy ahead of any coherent policy making for our country. I do think we've seen a microcosm of that today, and I think we saw it as well during the second reading. Now, with most of the amendments that we've seen submitted in the third reading, it does appear that they don't have a problem with the substance of the change that we're offering, so I look forward to seeing many of them march through the eye lobby with us. I do note that the other place does play an incredibly important role in our democracy. They do both scrutinise and improve legislation passed in this place, which has been very welcoming, depending on who you ask, over many years. But the change we're considering today is very simple, and it's necessary to fulfil the promise that we made at the general election, that we would end the outdated practice of hereditary peers. Now, I may not look it, Madam Chairman, but I am old enough to remember the last Labour government. They started the process of reforming the other place, and it was clear then, as it is now, that it was a transitional compromise. It may have taken a while, but it falls on this government to see through the work they started. This is an incredibly simple and effective change to the other place, and I urge all members of this House to support it.
Sir Gavin Williamson.
Thank you, Madam Chair. I do appreciate the opportunity to have tabled a number of amendments to this piece of legislation, very much with approach and the hope of improving this legislation, making sure that we actually get this legislation into the best possible place to deliver actually change in order to be able to ensure that the scrutiny of laws that go through this House is done in a better and more democratic way. Now, I do appreciate that in politics there's a certain amount of robustness, there's a certain amount of argument, there's a certain amount of, sometimes being described as the Punch and Judy politics that we all sometimes despair at. And I think we should be looking to do more and to do better. There are a number of things that the Labour Party set out in its manifesto that I think do command wide and broad public support. There are a number of things that the Labour Party didn't spell out in its manifesto that they are implementing that most certainly don't. But what does, I believe, command broad public support is some of the changes that they set out for the House of Lords. I personally think that, and this is why I've tabled new Clause 4 and new Clause 3, because I firmly believe there is strong support in order to see an introduction of a minimum contribution in the House of Lords. Of course, I would happily give way.
Right, Honourable Member for giving way. Does he accept that the amendment NC4 doesn't take into account illness or maternity or paternity, and that 8 weeks is perhaps a little too short?
I think what would be absolutely... I think that new Clause 4 clearly sets out an intention to deliver on what the party's manifesto, the party opposite manifesto, wish to introduce. And I'd be quite happy to work with the front bench opposite, and including with a spokesman from the Liberal Democrats, to make sure that this legislation gets into the best possible place. And I actually, as I look at some of the attendance in the upper house, I'm a little bit shocked, Madam Chairman, because I look at this, and in the 2019-2024 Parliament, of the 966 members eligible to attend at least some of the last Parliament, do you know, 28 of them did not attend at all, did not even bother to turn up. 116 of those members attended on less than 10%. 10% of those sitting days. Well, that does not feel as if that's particularly active. So I can quite understand why the front bench opposite, as they were in opposition and they were looking at what their manifesto should say, they quite rightly alighted upon this and felt that it was something that needed addressing. And that is why I've tabled new Clause 4, because I firmly believe not only is there support on those benches for this, because you would assume as they stood for on the Labour Party manifesto, they would at least have some support for what they were proposing. There is support from it on this side of the House. And during the same period, 158 members of the upper house voted in less than 10% of the divisions that they were eligible to vote in. And most members... Of course, I would absolutely...
Julian Lewis.
I hate to strike a discordant note with my right honourable friend. He and I have fought shoulder to shoulder in many battles, but is it not an illustration of the Pandora's box one might be opening to consider what would the situation be if all these people all turned up at the same time? I doubt very much the upper chamber would be capable of handling it, which then leads us to the question of how you reduce the numbers to a manageable proportion. So he's getting into difficult waters with all of this. He'd be better be careful what he wishes for in getting all these people to converge on the House of Lords all at once.
Well, Madam Chairman, my right honourable friends and I agree on so many things, many things, but maybe I am just wanting to see that change happen. And actually, I believe that actually by introducing new Clause 4, actually introducing the Labour Party's manifesto commitments as part of this bill, actually what we could do is significantly reduce the size of the upper house and actually avoid such an intimate crush that my right honourable friend sets out. And of course, I'd be delighted to give way to it.
Not to pause the honourable gentleman whilst he's in the middle of his intimate crush. But as someone who is always a fan of a clause 4, I mean, I understand what the honourable gentleman is trying to achieve with this clause. I would put to him one point that under subsection 2 of his proposal, participation in a division would in of itself not be the only thing required. A member could simply turn up, be seen, take their seat. They wouldn't have to take part in division, they wouldn't have to contribute. So his own clause doesn't actually achieve, I believe, what he is seeking to achieve. But would he also, perhaps, when he does bring this back, undoubtedly to a future bill, would he consider retrospective application? Because one of the things I would worry for is there are a number of members of the other House who have not turned up for many, many weeks, months. In fact, there are some who, over the last 2.5 years, have an attendance rate of less than 5%. Would it not be wrong for them to simply turn up now, get their tick, and then wait 8 weeks? Actually, if we were to say, let's retrospectively apply this from today, then he would have a huge clear out of those people that have not made any contribution so far, and given they haven't turned up so far, they won't be missing much.
Well, Madam Chairman, I'm getting excited that the honourable members may be discovering a little bit of radicalism that I always personally felt I was in his heart there, but maybe the sort of the eye of a whip has sort of squeezed it out of him of late. But I think the honourable gentleman makes a very thoughtful and interesting point, and I think that I would very much like to work on a cross-party basis to get the legislation in the best possible place. And I think that he raises an important point. Indeed, I will do. But I was just going to sort of raise on the issue of minimum contributions. There are a number of peers in the upper house that have continuously failed to make a significant contribution, and there are routes for them to be able to exit out of the upper house, but they've chosen not to do so. And I think that does cause real problems and real challenges for the upper house, and it would be a way of new clause 4, I believe, tackling that. And of course, I'd happily give way.
And I think I'm going to agree with what he's going to come on to suggest. But can I ask him whether we're being a little bit unfair on their lordship, since clearly a lot of them didn't get the memo that says you get appointed to this high honour and you will turn up and do some meaningful work. And some of them think they're simply at the apex of the UK honours system. It's not the fundamental issue that we fail to separate the two. That's to say, the honours system and doing a piece of work in our parliament.
Sir Gavin Williamson.
I think my right honourable friend is absolutely spot on there, and I think that there has sometimes been that confusion, and I think that actually new clause 4 or anything that the government would sort of look forward to bringing forward as backed up by their manifesto and popular support for such a move would mean that we could actually get the upper house working much, much better. Now, Madam Chairman, if I can take the opportunity to move on to the introduction of a mandatory retirement age. Again, another thoughtful and, dare I say, far-reaching policy of the party opposite that was in their manifesto. And can I just pay tribute to the Paymaster General? We all know that the Paymaster General is one of the finest authors in this House, and his publications are still available on Amazon. Not quite as sought after as the former members for Uxbridge, but hopefully by giving it a little bit of but I'm sure the volume on Keir Starmer that will be, the Prime Minister that will no doubt be coming forward in the future will be a real hot seller. But he is a great author, and he came up with the mandatory retirement age, I imagine, and it is a good policy. It's certainly something that is worth including in this piece of legislation that he's bringing forward. It can be, it isn't onerous in terms of adding too much to the bill. It would have a significant impact in terms of reducing the size of the House of Lords. We do know that the House of Lords is the largest legislative chamber outside of the People's Republic of China. The simple act of introducing the mandatory retirement age, as was so a key part of that Labour Party manifesto, will reduce the number of life peers quite considerably. It will also have a significant impact in reducing the cost of the House of Lords. And of course, I would happily give way to the father of the House.
I'm sorry to declare an interest, but why is my honourable friend so ageist? Some people are wonderful at the age of 80 and other people are useless at the age of 50.
My right honourable friend makes a very powerful point, but I think we have to respect the fact that the party opposite actually did achieve a majority at the last general election. They had a manifesto in order to enact, I think the phrase was change, and this is an opportunity to do it, but there's a timidity to it. They sort of seem to be frightened. I'm not sure if maybe I would hate to sort of make the suggestion that deals were done with previous members of this House that were meant to be sent up to the other House, that they would not introduce this change, as this would mean to their automatic exclusion or such like. But that would be for certainly something that I wouldn't be wanting to imply. But we do need to see this change. New Clause 3 would enable the government in order to be able to deliver on its manifesto. And I think that's important, because there has sometimes been a talk about the breakdown in trust in politics. There's been sometimes a talk about the fact that actually we need to build confidence in politics. Well, the best way of building confidence in politics is setting out our manifestos. One party wins, one party loses, and then delivering on that manifesto. And this is a great opportunity to do that. I appreciate that both the Paymaster General and his honourable friend have set out to the House that future legislation is coming. I personally do think that is a slightly optimistic view. And I've sat on PBL committees in the past. I understand the pressures on the legislative timetable. I think if the Paymaster General is under the illusion that he'll be getting waves of new bills going forward, he will end up at the end of his ministerial career slightly disappointed about that eventuality, because it simply is not going to happen. And finally, Madam Chairman, if I can turn to New Clause 1 and New Clause 2. And I do accept that these clauses were not in the Labour Party manifesto. Of course, I'd be delighted to give way.
I thank the honourable gentleman for giving way, and it's great to hear him speak of the Labour Party's manifesto at the last election, and of course to talk about how important it is that we are able to get through our programme for government, having been elected with such a resounding win. I wonder if that extends to his support for other areas in our manifesto, such as, for example, the Employment Rights Bill. Will he also be supporting that?
I'm sure he will.
Sir Gavin,
there's lots of areas of the Labour Party manifesto that I'll agree with, and there are lots of areas that I disagree with. But the honourable lady is in a very fortunate position of a great deal more power than any members upon these benches, where she can actually bring influence to bear on her front bench. And I would urge her to do so, because there is an ability within this bill to deliver on a number of the commitments that she made to her electorate, and that Keir Starmer, the Prime Minister, made to electors right across the country. And I would encourage the honourable lady to use her position of influence and power to actually encourage the front bench to deliver what she was elected to deliver. And there will always be areas, of agreement on both sides of the House. There will occasionally be areas of discord where I am not always able to agree with my front bench. But I think this is an opportunity to deliver what the Labour Party promised. And of course, I'll give way to Bill.
I do thank the honourable gentleman for being so generous and gracious with his time. He rightly points out that his New Clause 1, New Clause 2 is not manifesto commitment this party made. So he will understand why it potentially causes the bill to become unstuck when the Salisbury Convention is applied at the other end, which the Minister, I know later, is going to confirm. But in terms of new Clause 3 and new Clause 4, can he tell me, has he used his position of power and influence to confirm that should that amendment be made, that his members, his party's members in the upper house, where they have a plurality, where they are in the majority in most votes, that they will support what he is proposing, and that therefore this bill can still make passage through the House of Lords to deliver on the one thing we all have consensus on?
Well, the honourable gentleman flatters me in the sense that I actually have any power, whereas once, as a former chief whip, I could have maybe have had some a gentle nudge on the tiller in order to be able to make things happen. Sadly, the only army that I can bring to bear is myself, but I will happily do what I can in order these two important new clauses to actually make them happy, and I'll be very happy to walk side by side with the Paymaster General through that lobby to deliver for his party on his manifesto commitment. But that is the only commitment I'm afraid I can do, because I would not wish to overpromise. But that I will do. And of course I would give way to the honourable gentleman.
I thank the right honourable gentleman for giving way in his very entertaining speech. He makes several references to our manifesto, but I'd like to make some references to the Right Honourable Gentleman's Party's manifesto. Quite a few references to reform.
I just remind the member, I hope this is on the House of Lords and within scope of the bill.
It is, thank you, Madam Chair. It is relating to references to reform of the House of Lords. There are no references to reform of the House of Lords in that manifesto. Lots of references to peers, one reference to peers, but not to peers in the other place. A few references to the Constitution, but not our unwritten Constitution. So, will the Right Honourable Gentleman tell the House just why he is now so fascinated by the measures that we're debating today?
Well, I thank the honourable gentleman for making a point, and I certainly hope it's noted on by the whips the support he is trying to offer there. And I will just bring the honourable member's attention to 2012, where there is a very significant body and attempt to make major reform to the House of Lords. And it was something that I was actually voting for. I wanted to see that reform in 2012 as I wished to see that reform in 2024. Yeah. And it may shock the honourable member, and maybe it starts to undermine his faith that he joined a party that had radical traditions or a sense of actually wanting to deliver any sort of reform or change, because it was actually his party. It was the Honourable Gentleman's Party, sorry. It would be the Honourable Gentleman's Party that voted that down and made sure that it could not proceed. But I'll, of course, be happy to give way to the Honourable Gentleman.
The Right Honourable Member makes mention of the 2012 bill. Could he enlighten us as to how his party voted on that occasion?
I would be more than happy to do so. More members of the Conservative Party voted in favour of it, and the only reason that that piece of legislation collapsed was not through the lack of support on Conservative benches or Liberal Democrat benches. It was the fact that Her Majesty's, at the time, official opposition was going to vote against it, which meant that the numbers weren't going to stack up. So therefore, it was a decision by the Labour Party and the leadership of the Labour Party to collapse that piece of legislation that meant a significant body of reform did not happen. And if I may turn to the Labour Party manifesto, and I'm sure it's something that maybe the honourable member has had a glance at, but possibly not. It sort of does say on page 108, it says legislation to remove a right of hereditary peers to sit and vote in the House of Lords. Labour will also introduce a mandatory retirement age. Yeah. At the end of the Parliament in which a member reaches 80 years of age, they will be required to retire from the House of Lords. And then on the subsequent paragraph on page 108, Labour will ensure all peers meet the highest standards the public expect of them and will introduce a new participation requirement, as well as strengthening the circumstances in which disgraced members can be removed. These are perfectly sound points of policy which the party stood on at the last general election, but now just chooses to ignore. And I appreciate the honourable members are wishing to make brownie points, and I'll let another one make a brownie, earn his brownie points and edge that little bit closer to the allure of a junior PPS ship right now.
The honourable member remind me how long a parliamentary term is and therefore how long we have to implement our manifesto.
Member responds. Can I just remind members that they really should be in for the duration of the debate or make an effort to be in for a considerable duration of the debate before intervention. Sir Gavin Williamson.
I can only say, Madam Chairman, and thank you for your firm chairmanship of this debate. I think the honourable member made a very strong and powerful intervention, which I hope is noted down, and I can see him being the Parliamentary Private Secretary for the Junior Minister in the Department of Environment, Food and Rural Affairs very, very soon. And, you know, I'm not sure if my commendation and support helps you in your endeavours, but I hope it does. But of course, the honourable member makes a very thoughtful and interesting point. There's actually this, the government does have time and introduced further legislation. But the reality is, the pressure in terms of actually the time of this place is one of the greatest pressures. Time is the most precious thing. And I certainly would not engage in any form of political betting if it could be just taken down for in Hansard here. But if I were a betting man and I would have, in a previous age, I would maybe have offered this wager to the Paymaster General, I would wager a whole £5 that the Paymaster General will not be in a situation of getting any more legislation on Lords reform. And I will give way to the Paymaster General, who is going to refute this. Or,
come on. I would just say to the right honourable gentleman, I certainly wouldn't enter into a wager, and I'd have hoped the Conservative Party would have learnt their lesson on that.
But what I was hoping, Madam Chairman, that the Paymaster General would do is actually give a real categorical assurance that there is going to be further legislation. In the next King's speech, there is going to be a retirement age in the House of Lords introduced as part of that legislation. There is going to be a minimum participation introduced. But he stays silent. He makes a little quip. And I will give him another opportunity. Does he believe it will be in the next... I know that the right honourable gentleman will probably stay in his position, which of course is his right. But if I can, of course, yes.
I don't know where this naive assumption belief that there will be further Lords reform comes from that exists on the benches of the Labour Party. There won't be any more. I was here during the 90s where they attempted to bring in Lords reform and they gave up immediately with no intention of ever bringing it back. This is it. This is all we're going to get in this House, and unless we make this a good bill, this is all we're going to get in this Parliament.
I thank the honourable gentleman for making an incredibly powerful point, and he's absolutely right. He's a veteran of these arguments, and he knows how it will go, because we've seen it before. And this is the moment. There is not going to be another one. This is it. And if I can turn to new clauses 1 and new clauses 2, and for me this is of all the clauses that I've tabled, for me the most important clauses, because I think and feel it is fundamentally unfair that we still have a situation where you have a block of clerics that have a right and a say over our legislation, over the way that my constituents live. I just cannot see how in today's world that can be justified. I think as you look at it more and more, and we've not seen the arguments that have come forward as to why these 26 bishops should be defended. But to me, I will give way in a moment. For me, as someone who is an Anglican, I cannot see why I have a greater right for greater representation than my children who are Catholics. I cannot see, I'm often told that, well, since the Reformation, the bishops have been there. Well, there are lots of things that were happening around the Reformation that I'm not that keen to see happening today. And I appreciate that the Paymaster General may have a very different view on this matter, and he wants to sort of revive some of those age-old traditions. But I do not. This is an opportunity that doesn't jeopardise the bill, but actually has the ability to improve the legislation that we have in front of us. I do respect the fact that it isn't in part of a Labour Party manifesto, but I do ask those members across the House in all conscience as to whether they think it is right that this anomaly continues to exist, and they will vote to support for it to continue to exist. I think, for my perspective, Madam Chairman, this is an issue of conscience. It's an issue of what we think is right and what we feel is right. You have those 26 bishops. They don't come from every component part of the United Kingdom. They don't come from Wales, Northern Ireland and Scotland. They only come from England. The composition of those bishops is probably not reflective of today's world. And what I would also be concerned about is the fact that I fundamentally feel it is wrong that whether you have in statute, based from the statutes of 1847, the Archbishop of Canterbury, the Archbishop of York, the Bishop of London, the Bishop of Durham, the Bishop of Winchester, all of those bishops and archbishops have a right to legislate on my constituents. I believe they have an absolute right to be able to influence the course of public debate, but from the pulpit, not in Parliament. Of course, I will give way to my right honourable friend.
I'm grateful to my right honourable friend giving way, and it allows me, on that basis, to give him a short lecture on the character of conservatism. What he needs to understand is the collective wisdom of ages, vested in great institutions like the monarchy, which, by the way, is hereditary, and the church, and this parliament, and the small institutions, what Burke called the little platoons, that collective wisdom, transmitted in age-old form, as he describes it, is always more important than the fads and fashions of any one generation at any point in time. If he understood that, he'd understood why he was conservative.
Well, Madam Chairman, I always have felt that the right honourable member for South Holland and the Deepings was the collective, historical, accumulated wisdom that we could ever possibly want. But I've always believed that the greatest strength of conservatism can be the ability to reform and to have a radical approach in order to be able to change our country and the world in the shape that we wish to see it in.
Very grateful to my right honourable friend. I'm very much warming to what he has to say. He speaks of the of the Reformation. He's right to do so. But will he recall that there were two Reformations, broadly speaking, in this country? There was the English Reformation. There was, of course, the Scottish Reformation. And we never have any discussion about the place of the other established church, the Scottish Church, in our constitutional arrangements. That seems to be a quirk of history, and I'm not for one moment suggesting that moderated the Church of Scotland should sit in the other place. But it does underscore and highlight the issue that my right honourable friend has raised with the position of the English bishops.
I think my right honourable friend is absolutely correct. There are, where we see the position of the Lord Spiritual throws up more questions than it actually does answers. And this is why I would deeply urge the Treasury bench to look at this amendment, to actually ask the question of can they make their legislation better? Can they be the government, as I think they wish to be, in order to be able to deliver that change? Of course, I'll give way to the honourable gentleman.
Very grateful to the right honourable gentleman for giving way. I certainly share much of his zeal on the removal of the bishops from the Lords. Does he also share my concerns around the privileged speaking and seating positions they have within the Lords as well?
I do, and I'm looking forward to, if we get the opportunity to have a division on this, to the honourable gentleman joining me in the division lobby, because we can sort that problem out with this piece of legislation by voting to get rid of them, and therefore there will be no privileged seating arrangements, and a little bit more space for the honourable member for Stoke-on-Trent Central's wife, in order to, and all other members to be able to enjoy on the government benches, as I think that is where they do sit, if I recall, and of course the right honourable lady as well, her husband as well. I can go through all the arguments of the presence of bishops in Parliament. There is only one other sovereign country that has clerics within their parliamentary body, and that is Iran. I do not think that is necessarily the best model for us to base ourselves on. This piece of legislation gives us the opportunity to be able to have a more reflective parliamentary body. If we look across Europe, there are many countries that actually have a strong faith and where the religion plays an incredibly important part in national debate and national discourse. But none of those countries, whether it is France, whether it is Germany, whether it is Italy, whether it is Spain or Portugal, feel the need to have that assured clerical block of bishops within their legislature. The Church of England, less than 2% of the British population now attend Anglican services on a Sunday. And by taking this action in order to remove the bishops, we make the recognition that Britain is a changed country. Britain is very different today than it was in 1999. And if we look forward to probably when there is another piece of Lords reform legislation that will come forward in probably another 20 years, Britain will be changed again. So let us use this opportunity to make sure that the upper house is more reflective of our nation. And there is a reality, is that the Lord Spiritual don't take part in many divisions. It's 14% of divisions. If the party opposite introduced some of its sort of participation requirements, it would actually probably mean the exclusion of a number of bishops. And data has shown that the support for having bishops in the House of Lords is incredibly low. Indeed, even in the Anglican Church, support for having bishops in the House of Lords is incredibly low. 60% of priests back reform to the bishop's bench. And actually, going back to the 2012 legislation, there were proposals to shrink that bishop's bench from the current 26 to 12. Yet the party opposite has shied away from all attempts to even do the most modest reform. There are just simply no credible examples of where it is reasonable to have bishops legislating on our constituents. And the party opposite, the only argument seems to be is this is a simple bill. Well, Madam Chairman, this is a simple amendment. It is not right that so many of our constituents who do not have an Anglican faith are legislated on by Anglican bishops. We have to make these changes, and we have to make these changes, and we have to seize the opportunity, because this will be the last and it will be the only opportunity while this government is in power in order to make these changes.
Phil Brickell.
Thank you, Madam Chair. It's a pleasure to serve under your chairmanship. I would like to speak in support of this bill, which I believe is long overdue, and I would also like to thank the Minister for her contribution and welcome in particular her warm words on the importance of this bill as a clear manifesto commitment to reform how the other place functions as, and I quote, an immediate modernisation. Since the groundbreaking House of Lords Act was passed in 1999 by a Labour government, there has been no substantive reform to the hereditaries in the other place, despite obvious public appetite to do so. Indeed, a study conducted by University College London's Constitution Unit found that only 6% of respondents supported the current system. Now, before having the enormous privilege of representing the people of Bolton West, I spent over a decade tackling bribery and corruption time and time again. I've seen how trust is only developed when those responsible for decision-making are truly held accountable. I'll focus on that word, accountability. That's something that's gravely lacking with the remaining hereditaries. Over the course of my working career, it's become clear to me that the UK has an important role to play on the global stage as a world leader on political integrity. But over recent years, this country's reputation as a well-governed and, frankly, a clean jurisdiction has been degraded, and countries who previously welcomed our council with open arms now look on it with scorn, which is why this long overdue reform matters to me and why I am passionately supporting the government on this bill. Now, I am sure there are some hereditary peers who undertake hard work, and I have no doubt that many have a genuine commitment to public service. But the concept of hereditary peerages, of hereditary privilege, of being able to legislate for life merely by dint of birth belongs in the same breath as second jobs, as lobbying scandals and the revolving door. It is an anachronism which needs to go. Now, contrary to the protestations from members of the Conservative Party opposite, this bill is not about spite, Madam Chair. Rather, it is about improving trust and improving accountability in our politics. And the public expect high standards from our legislature. But the simple fact is that too many hereditary peers do not play a proper role in our democracy. That was a point we made in the Labour manifesto earlier this year, and which members opposite will no doubt note resulted in a resounding mandate across the country to deliver change. Yes, I will give way.
Frankly, the facts do not bear out what the Honourable Gentleman said. If you look at the record, hereditary peers tend to speak more often in debates, proportionately. They tend to be more involved in tabling amendments. They tend to be more often whips in the other place. So they are more active in proportionate terms than the appointees that also, by the way, lack democratic literacy.
I thank the right honourable member for his contribution. He will note that I did not mention activity or participation, actually, in the House. I mentioned democracy and democratic accountability, which hereditary peers, of course, do not have. Well, we'll come on to live peers shortly as well. This is important change in the manifesto, change which Madam Chair will, of course, recognise that is important because we need to have equality of representation. That's vital if we are to retain confidence in both how this House and how the other place operates. Now, it's been 66 years since women were allowed to sit in the other place, and yet currently there are no women amongst the hereditary peers there. I, for one, am embarrassed by this, and I think it is a disgrace. And as a member from the North West, it has not escaped my attention, nor that of my constituents, that, frankly, individuals from my part of this great nation are underrepresented in the other place, particularly, again, amongst the hereditary peers group. 35% of hereditaries live in London and the South East, according to the Electoral Reform Society. I do not accept that, frankly, hereditaries who are the son of a duke, of an earl, of a viscount, of a marquess, that they are any better prepared to scrutinise legislation than the daughter of a plumber or the son of a nurse. Yes, I will give way.
Madam Chairman, he's making an incredibly powerful speech and one of great merit. Does he believe that actually it's right for the English bishops and only English bishops to be able to vote on Scottish and rule the roost over Scotland, Wales and Northern Ireland? Very much akin to his arguments that he's making just there.
Well, I admire his penchant for House of Lords reform. I will come to some of these points later, if I may. But the consequences of not acting, are no less than existential for trust in our politics, and in this place and in the other house. Trust in politics, I'm going to continue, if I may. Trust in politics is at an all-time low. A legacy of 14 years of cronyism and corruption from the party opposite. Indeed, the UK Anti-Corruption Coalition carried out polling. If he may listen to what I've got to say, I think he will reflect on it. The UK Anti-Corruption Coalition carried out polling earlier this year, which found that 2/3 of respondents, let me repeat that, 2/3 felt that the UK was getting more corrupt. And in 2023, only 12% of respondents told the Office for National Statistics that they trusted political parties. It all adds up. Turnout in July was 60%, the second lowest in a UK election since 1885. And at a time when autocratic hostile states seek to undermine us at every turn, democratic engagement has rarely been so important. So, Madam Chair, I believe that this bill is a small but important step towards restoring that trust, as my right honourable friend the Prime Minister promised we would do during the election campaign. The House will also note that I very much hope are the impending appointments of an Ethics and Integrity Commissioner, an anti-corruption champion and a COVID corruption commissioner, all of which are vital measures alongside this bill to improving standards and increasing accountability. Madam Chair, I would urge the Government to confirm these appointments as soon as possible. These are further steps to showing the country it's vital to regaining trust in politics as a means of improving lives for all. I will give way on this occasion.
Very much for giving me. Thank you, Deputy Speaker. We talk about trust in politics, which is a very, very valid and important point to raise. And the statistics, which the honourable member has just spoken about, showing a deterioration more recently in trust in politics over the last couple of decades. That's probably something for us all in this chamber to reflect on as the politicians who are the newest in the House. I'm not sure how hereditary peers who have been serving for decades when trust in politics was far higher are to blame for modern lack of trust in politics. That's something more for this House, for those newer members who have turned over more recently in times and arrived here more recently in times than people who have lifelong served in the other place diligently in that chamber.
Well, I thank the member for his contribution. What I would say, of course, is that hereditaries are there by dint of birth. They are not there by dint of their contribution and service in public life. So when he talks of decades of service, that may accrue over a period of time, but that is merely by dint of birth. And we will come to appointments to the other place very shortly, which touches on that point about accountability and trust. Now, I want to come to the various amendments brought by the Right Honourable Member for Stone, Great Wyrley and Penkridge. I will only say, Wyrley, I will only say, as colleagues have done, it's a great shame he did not discover he had such a penchant for reform and modernisation during his 14 years as a member of this House for the governing party. Yes?
You know, I would just point to the honourable gentleman as I was voting for House of Lords reform in 2012. So I do hope the honourable gentleman will take the opportunity to withdraw that when his own front bench in 2012 was actually voting or indicating they would be voting against it.
Two strikes. I will continue, Madam Chair, if that is okay. In fact, unless I'm mistaken, prior to the previous debate on this bill, this was the first time that the Right Honourable Member has actually mentioned House of Lords reform in this place. Now, the Right Honourable Member for Brentwood and Ongar, and also for Stone, Great Wyrley and Penkridge, have correctly noted that our manifesto included many of the amendments that the party opposite is pushing or has attempted to push today. Like them, I'm sure I look forward to working with our front bench on further modernising commitments, which were enshrined in our manifesto, which I can assure members opposite I have read, namely changes to the appointments process to improve the national and regional balance of the second chamber. Yes, a mandatory retirement age. I quote, a long-term commitment to replace the House of Lords with an alternative second chamber that is more representative of the regions and nations. And yes, a participation requirement. But I'm sure the members opposite agree with me that anything as knotty and unwieldy and fundamental as constitutional reform will inevitably have to be incremental. Doing too much too soon may otherwise leave damage. I note, of course, that the party opposite took this logic to an extreme over the last 14 years by bringing forward no substantive reform whatsoever. There was no mention of Lords' modernisation in the Conservative Party manifesto, as my honourable friend from Rugby has mentioned already. That's right. And the meagre changes made under previous Conservative administrations comprised of nothing more than tinkering around the edges, at a time when the other place needs to be urgently dragged into the 21st century. I must say that I will not be supporting the amendments, and that if those present are genuinely committed to modernising how our democracy works, I look forward to constructive engagement with the government and them through the course of this Parliament. I commend the actions taken so far by the government and will support further measures over time to modernise how the other place works. A mature democracy such as ours, centred around the mother of all parliaments no less, simply cannot continue with an unelected, hereditary upper house. Now, we heard earlier from the Right Honourable Member from Brentwood and Ongar talking about gerrymandering. His words. Let's talk about gerrymandering. Let me recall one statistic worth reminding this House about. For every 1.5 days that former Conservative Prime Minister Liz Truss was in power, she created a life peer. Yes, life peer. 32 in total. Shocking. During the course of a 49-day premiership. Much like the hereditaries, these new legislators will have a seat in the House of Lords for life. How can that be right? Indeed, it's clear to me that the House of Lords Appointment Commission does not present a particularly high bar for appointments. So once this immediate first step is completed, there are a number of ambitious steps which must be taken to deliver genuine, lasting reform of the way we do politics in this country. In summary, Madam Chair, this bill will help to wrench our political system kicking and screaming into the 21st century. The party opposite, including the Right Honourable Member for Stone, Great Wyrley and Penkridge, sat on their hands for the last 14 years. We've been here for 4 months and we're already delivering. I look forward to voting for the bill tonight.
Pete Wishart.
Ever so much, Madam Speaker. Madam Speaker is today. Sorry, I'm making sure we get the right title for you. I rise to speak in support of New Clause 11, New Clause 12, 9, 10, 13 and 14, which stand in my name and all the associated amendments that go with them. But I will also support any amendment today which seeks to reduce the size of the House of Lords and limits its authority in the legislature as long as the House of Lords remains a wholly democratic institution. You see, I'm quite a simple soul. I'm just someone who intrinsically believes that if you represent the people, you should be voted by the people. That to legislate requires consent through some sort of electoral mandate, a group of people who vote for you to go into a legislature and to represent them and allow you to make the laws of this land. It's a simple belief, and I think it's one that's generally supported by the majority of the British people. Certainly, latest opinion polls when it comes to the House of Lords show that there's only about 1 in 7 people in the UK that think the House of Lords in its current condition is worth supporting. A vast majority now want a fully elected House of Lords. That's what they promised. That's what they said they would deliver. That's what they commissioned Gordon Brown to go and do, and he came back with the report that said he would do it. And of course, it hasn't happened. Now, I'm almost touched by their naive belief and faith that there's going to be more than this bill. It's actually quite touching to think that they actually believe that there's going to be a succession of legislation that's going to come through, that's going to incrementally deal with all the issues of the House of Lords. Sorry to break it to them. It's not going to happen.
Thank you. Look, I thank the member, Madam Chair, for taking intervention. His party have long talked about constitutional change in this country, but it's our party who delivered devolution in Scotland, in Wales, in Northern Ireland, and a Mayor for London, a London Assembly, where his party have only talked about it. Isn't that the reality of this party delivering on constitutional change?
And I'm grateful to the honourable gentleman. Yes, of course, we're delighted we've got the Scottish Parliament, and I congratulate and thank the Labour Party for delivering, and they were right. But they've never delivered anything when it's come to the House of Lords except the reforms in 1999. That's the only thing that they brought forward other than this pathetic little minuscule bill that does something that should have been done centuries ago, and we're supposed to congratulate them and thank them for actually getting rid of the most ridiculous class of parliamentarians anywhere in the world, the hereditary peers of England, Scotland, Wales and Northern Ireland. It is absurd. Well done for finally getting rid of the barons, the dukes, the earls and all the other assorted aristocrats. That should have been done centuries ago. The commitment I'm waiting for from the Labour Party is the commitment that they gave over a century ago. Do you know what that was? They don't know what that was. I'll tell them. They actually said this, a Labour Party commitment from, I can't remember the year, but certainly over 100 years ago, we will abolish the House of Lords. That is a historic commitment that was given by the Labour Party that they've not even come close to realising. But they are, thank you Labour Party, getting rid of the earls, the dukes, the barons and the graces. So I suppose we've got to be thankful to them for that. I'll give way to the right honourable gentleman.
I thank the honourable gentleman for giving way, and it'd be very interesting his assessment on how that radical reform from 100 years ago is actually going in his view. But also, you know, I appreciate that he may not have studied this manifesto, as many members opposite haven't done either. But as part of that, it does actually say that they aim to make a second chamber more representative of the regions and nations. And I wondered if he could sort of share his thoughts of how that's going and whether he thinks Mrs Gray will be able to contribute to that in a significant manner.
Let's just say that progress hasn't been all that was anticipated and that we hoped for. And we could actually say that progress has been practically non-existent. And of course, we've got the crushing news today that our British envoy to Scotland will no longer be coming there to represent this Parliament as part of our duties in the nation's region. I tell you, Madam Chair, that there is a nation in Scotland just now which is almost inconsolable about the fact that our envoy will no longer be coming to Scotland. We were practising the street parties in the Haka just to make sure that she was properly welcome to our northern territories, and she is no longer going to be there. Give way to the honourable gentleman.
Thank you, Chair, and I thank the honourable member for giving way. And although he seems to want to get rid of hereditaries from this place, his own party seems to want to create a system of hereditaries by allowing the member for Aberdeen South to stand in the Scottish Parliament.
Oh. Can I break it just ever so gently to the honourable gentleman? There will never be anybody from this particular bench that will end up in an undemocratic outrage like that place down the corridor. I don't know how many of them will be in Parliament for 20, 30 years. I remember the last generation of Scottish Labour MPs that confronted me across the benches. I think there's about 15 of them now in the House of Lords. This conveyor belt of serving a distinguished career in the House of Commons to be rewarded by a place in the House of Lords is one of the things that I want to address in my amendments. I'll come to my amendments, Madam Chair, because I know that you're looking at me to do that. Well, I had hoped to bring an amendment to just try and deliver that historic commitment to abolish the House of Lords. Now, I knew I was highly... I'll make this point, and I'll give way to the honourable lady. I knew that I would be highly unlikely, because of the good work of the Clerk's office, that I would be able to secure such an amendment. And it was probably right that I didn't manage to secure that. So I thought I'd try and be creative to see what we could do to see if we could realise Labour's ambition to abolish the House of Lords. So I thought I'll try and abolish the membership. So what I did was I offered a series of amendments that tried to get rid of all the distinct groups and classes of members of the House of Lords. And I thought, again, Madam Chair, that I would be singularly unsuccessful in that mission and endeavour. But I've got 3 of them on the order paper, and they are crackers, believe me, Madam Chair. And I'm so looking forward now to speaking about them, because I've managed to secure amendments that will abolish the donors, will abolish the appointees, the cronies that the Prime Minister appoints to fill that place, and to abolish this idea that I've just described, that former members of Parliament can this naturally assume that they will get a place in the House of Lords. So I am really pleased with myself, Madam Chair, and I'll come on to them right now, but I will give way to the Honourable Lady, as I said I would.
Well done.
Thank you, Madam Chair, and I thank the honourable gentleman for giving way. And indeed, it's a pity to interrupt him when he's in such a state of excitement about his work. And it's difficult to take a lecture from the honourable member for Perth and Kinross-shire on delivery when this Labour government is delivering so much in a few short days, and he may want to talk to his own colleagues in the Scottish Government about their delivery on issues like the health service and the state of it in Scotland, for example. But I would like to ask the honourable gentleman what his stance is on the multiple occasions in recent years where senior figures from his party have had to approach friendly peers from the other place to put forward amendments to legislation on their behalf. They're quite happy to use the chamber when it suits them, it seems.
Can I say to the honourable lady that there's a point of principle about our position when it comes to the House of Lords, and it's a little simple word called democracy. We refuse to have anybody in the House of Lords because we believe that people should have an electoral mandate, a democratic backing with the people of this country in order to serve in the legislature. That's just something that her and I will never agree about, because I believe that she's quite happy and satisfied that people like peers should continue to inhabit. Now, yes, as things go through the House, we actually have lots of hopes of the House of Lords that sometimes it might actually challenge governments and maybe make them think again, but they always back down. So any attempt to try and get them to agree to any sort of particular principle is practically a waste of time. I'm going to make some progress, but I'll give way again to the honourable gentleman.
I do thank the honourable gentleman for giving way. It's quite clear he's very pleased with himself for the amendments that he's able to secure today. The only seat potentially as secure as a seat in the House of Lords is a seat on the top of a regional list for proportional representation. So would the honourable gentleman perhaps take his very well-meaning amendment prohibiting anybody who served in this Parliament or the last from seeking a seat in the House of Lords, would he apply that to his own party and to the National Legislature of Scotland, so that if you served as an MP in this Parliament or in the last, you are not eligible to seek nomination to or election to the Scottish Parliament?
Ever so gently to the honourable gentleman, he should leave bypassing devolution to his friends from Scottish Labour, because they're actually just a little bit better at it than him. And it's their job to constantly speak about the Scottish Parliament and the Scottish Government. And to be fair to them, they have done a fantastic job. They barely even mention the UK Government. Every single contribution is about the Scottish Government. So maybe just leave it to them, shall we? But there was one amendment that I was hoping to bring forward, and it was actually quite an important one. It was discussed quite widely in the press yesterday. And again, I don't know if the honourable gentleman, predominantly honourable gentleman, on the side know this. They don't pay a penny of tax. Not one penny of tax. They're amongst the wealthiest people in this nation, but not one penny of the £346 that they get just for turning up is paid in tax. Now, I tried to get an amendment put on this to end that, and I cannot believe the surprise and astonishment that there is amongst my constituents, and probably quite a number of constituents across the United Kingdom, when this was made apparent. How on earth can that possibly be the case, that members of the House of Lords do not pay any tax on their allowance that they get just for turning up? And that's something that we have to address. So, of the great long list that will never be realised in the course of this Parliament, how about looking at this, dear Labour government? But the one amendment that I'm most pleased about getting on this order paper is the donors. The donors. The people who have a place in our legislature. People who could design, comment, reflect on the laws of this country, whose only seeming and apparent ability is to give large sums of money to one of the three main UK establishment parties. Now, we've heard a lot about trust from them. We've heard a lot about what the public feel about politicians and the political institutions. How about solving this one? How about taking money out of the legislature? How about saying that if you give money to one of the three big political parties, you are therefore naturally debarred from taking a place in the legislature? Now, my amendment, sensible amendment, deals with it in a stroke. No more cash for honours. No more lists of Tory treasurers being naturally given a place in the House of Lords. My amendment says if you have given more than £11,800 to one of the three establishment parties, you are not entitled to a place in the House of Lords. And if you have given more than £11,800 in the past to one of the three main UK establishment parties, you naturally give up your place in the House. What's wrong with that? Maybe the gentleman to tell me. No, I'll give way to the Honourable Lady, sorry.
Thank you, Madam Chair, and thank you to the member for giving way. Is the reason his amendment only refers to the first three UK establishment parties is so that it doesn't affect his own party now that they've fallen to fourth in this place?
Well, we don't put people in the House of Lords, so like if people want to give us £1 million, please, look, if anybody's watching here on TV, we could do with £1 million. Sorry to disappoint anybody who's thinking about that, but we cannot give you a place in the House of Lords. I'll give one last time to the Honourable Gentleman, because I've given way to him once already.
I do thank the Honourable Gentleman for giving way, and I agree with him about the necessity for probity, ethics and transparency in politics. And I also enjoy his righteous speech in this place. Obviously, he's a moral guiding compass for us all. So could he now make a clear and unambiguous declaration that not a single person who has ever donated to the Scottish National Party, served as a Scottish National Party member of the Parliament, has ever been given a publicly funded quango, a publicly funded seat on a board, they've been received a publicly funded donation for a role? Because obviously, I want to make sure we aspire to the bar that he sets, Madam Chair.
Could say categorically to the Honourable Gentleman is that there is nobody who has given one single penny to the Scottish National Party. And again, I appeal to people out there, if they want to give us money, please do. But one thing that we can never do, and never will do, and never have done, is in return offer a place in our legislature, our ability to govern in this country. We do not do that. We cannot do that, and we will never, ever do it. And let me just point to the scale of the difficulty and the problem when it comes to the donors. 68 out of 284 nominations from political parties between 2013 and 2023 were political donors handing over £58 million to one of the three main parties. In the course of that decade, some 12 of them gave £1 million. Now, that might be a familiar number for some of the honourable gentlemen and ladies on that side. £1 million is what you used to give the Labour Party under Tony Blair to get a place in the House of Lords in the 2000s. Come on, where's inflation when it comes to this? You expect at least £1.5 million to get your place in the House of Lords now. But the going rate seemingly is still about £1 million. Now, Cash for Honours was a disaster for them. It was absolutely awful. We saw the spectacle of a sitting Prime Minister being interviewed by the police about donations given to the Labour Party, which was interpreted as being an inducement to secure a place in the House of Lords. The Prime Minister was interviewed under caution, and 2 of his personal staff were arrested as a matter of that. Now, you would think that after that experience, some clarity to the thinking would take place, that they would all of a sudden decide, we'll never get into that type of territory ever again, that we will do everything possible to ensure that money is taken out of politics, and there would never be even a whiff or suspicion that this would happen again. But not a bit of it. Donors still go into the House of Lords, money still goes into the political party, and the public want it stopped.
What about Nicola?
And
yes, of course. I'm extremely grateful to the Honourable Way, and I intervene merely to say this. Many people might assume the Honourable Gentleman being foolish, raising issues of financial shenanigans, mismanagement, concealing money, bribes and so on, but I think he's just being brave. So just as a matter of record, I want it to be known by the whole House, this man is not a fool, he's a very brave man. Very courageous.
Well, I'm grateful to the honourable gentleman, and I'll never ever sort of chastise him again for quoting Proust when it comes to the House of Commons. And I'm sorry I did it to him last time around. Well, and I'm looking forward to that. So I thank the honourable gentleman. So that's the donors. But the other amendment that I managed to get through today, and again I'm quite surprised about it, is the cronies. I've got an amendment on the order paper that would stop this whole notion and idea that the power to appoint people to the House of Lords ends with denying this right to the Prime Minister. The Prime Minister has a power and a prerogative that is almost unknown amongst any other Western industrial leader, that he exclusively is responsible for appointing so many people in one part of our legislature. I think something like 30 to 40% of the total membership of the House of Lords has now been appointed by a Prime Minister. One man. Now, I believe that would make a tin pot dictator in a banana republic blush. He would want those powers in his hands immediately. But we've got them in the United Kingdom. We allow a Prime Minister to almost individually, on his own, determine so many people in our legislature. And it is something that has to come to an end. And of course, the temptation is to appoint your friends, to reward those that have been denied a place, to compensate people for losing their positions, to encourage people to take a role. But mainly, it's to make sure that the donors are rewarded. I'll give way to the honourable gentleman.
I think we can all pay tribute to the honourable gentleman for the genius of his crafting of amendments, which has sort of been very innovative. And the amendment, the new clause that he's talking about, actually, in some ways would, if you saw HOLAC being put on a statutory and independent footing, would go a considerable way towards dealing with that. And do you think that's something that his party would look at supporting, potentially?
If that comes up for debate, vote this evening, we will support that. And I think that's a one-way forward, and it certainly deals with some of the more egregious power that the Prime Minister has. And I think people across this country forget that our Prime Minister has this power, that he has this prerogative to practically design single-handedly a legislature. And I think the more people learn about some of these issues about the House of Lords, the 1 in 7 of them that support it in its current condition arrangements will fall to 1 in 70, because the place is an absurd embarrassment by the way it does business, by the way it allows itself its membership, and the way that it presents itself to the world. And we have this opportunity this evening to try and improve it, to try and deal with it, to try and see if we could get some sort of solution to what this country does on a democratic basis. But they're not grabbing it. They're not even prepared to kick out the bloody bishops, for goodness sake. How on earth can we be in a situation in 2024 where we have bishops legislating in a modern, advanced, industrial democracy? It is beyond a joke. Now, we're going to remove the hereditaries. He's right. The front bench of the government is right. There is no great objection to their hereditaries being removed. They're not even sensing much of a defence from some of the crustiest and oldest colleagues I have sitting next to me here. They're sort of half-heartedly feeling they're going to have to do it for their pals, but they're not sincere. They don't really mean it. They know it is up for the hereditaries. Quite rightly so. It is just absurd that there's still a feature of our democracy in 2024. So the bishops are going to stand out like a sore thumb in a cassock. They are going to be the ones that are going to be in the front line when it comes to the ridicule. Now, I've got a little suggestion for my friend, the clerics down the corridor. How about sticking to their ministries? It's not as if they're without a whole range of issues just now. Wouldn't they be better deployed in dealing with some of the things that we've seen in the news in the course of the past few days, far less concerning themselves with this attempt to run our country? We live in a multi-faith and no-faith complex democracy where so few people actually attend this church, this historic remnant from medieval times that we have to have bishops in the House of Lords, is totally absurd. And I will be supporting the Right Honourable gentleman's amendments tonight. He's only got them in his name because he beat me to the table office when I was trying to get the class of bishops taken out as part of my many amendments that I put forward. And the last set of amendments I managed to get on, they're probably, it's a bit more trivial, but I think it's still something we have to consider. And it's just this idea that former members of Parliament should just automatically expect a place in the House of Commons, because we all know what it's like, don't we? Towards the end of a parliamentary term, we're all asking each other, well, they're not asking me, but we're asking each other, are you going to get a place in the House of Lords then for standing down? And some of them, I think so. Because there's always that tap on the shoulder, isn't there, to the parliamentarian who's perhaps in the autumn of his or her career, where there's this, oh, would like you to do the right thing, colleague. Would you mind thinking about standing down? We've got a new, youthful, more energetic colleague who would perhaps be a bit more helpful to the Prime Minister. And we'll make sure you're all right. There's a place in the House of Lords waiting for you. How about just ending that? This is a feature that the public particularly loathe and despair of, and it just isn't right. If colleagues want to continue to have a place in their legislature, stand for election. That's what you do. That's what most parliamentarians across the world don't expect a place in the House of Lords. So I have a couple of amendments, Madam Speaker, which would deal with this, which states quite clearly that no one should be given a place in the House of Lords if they have been a serving member of Parliament in the current or last Parliament. And I think that's fair enough. Nothing could be, and I encourage the government to think about that as we go forward. I won't be supporting the Conservative front bench's amendments. I don't suppose they would be expected me to do so. I don't even understand them, and I don't really think that they understand it themselves. They seem to be encouraging the government to move quicker when it comes to House of Lords reform, and at the same time telling them that they're going too far. So I'll leave the honourable gentleman in the front to try and explain fully exactly what they're trying to achieve, because I'm having a real difficulty in following it. I will support the Liberals' amendments. I think it's a reasonable stab. But I always say ever so gently to my Liberal colleagues is, like they have more places in the House of Lords per capita than any other political party in this place. So maybe, if you're serious about stopping and developing the House of Lords, how about stop appointing people? And maybe that might have an impact and effect, because all this mealy-mouth, silly reform isn't doing anything to stopping the House of Lords. And I'll finish, Madam Speaker, on this. This is our only chance. There won't be any more House of Lords reforms, regardless of what they say. And I know they've said something to the backbenches to try and encourage them to come along today and tell them that there will be further reform coming. There won't be further reform coming. I think all of us, and I know I've got colleagues in the Conservative Party sitting on these benches who have seen this, been there, got the T-shirt. The T-shirt says, "No more Lords reform in this Parliament." That is what happened. I'll give way to the honourable gentleman.
Thank you, Madam Chairman. I'm very grateful to the honourable member for giving way, perhaps less so when I realise that I've put myself in his sights. I do think that if you look back to that 99 law that passed, it is tempting to be jaded, especially if you're in this place, at the thought that no more reform is coming. Would he accept that many of the members on this side of the House, including I think almost everyone today, is brand new and cannot be compared with that 99 cohort, and that we are prepared to take further more reforms within this Parliament as a result? After all, the public did vote for change, and we are here to deliver it.
I'll hold the honourable gentleman to his word, and I hope he's successful in trying to make sure that that's heard by his front bench. I'll also say to the honourable gentleman, though, and I don't mean this with any great disrespect, I've never seen a more malleable backbench than I have with new Labour members. They do everything to the bidding, and the way that they read out the crib sheets from the whips is absolutely magnificent. So I'm not actually seeing a great deal of rebellion going on in the backbenches, but maybe the honourable gentleman will show the way and ensure that something is coming. But I suspect that this will be our last opportunity to have a look at this in Parliament. The long grass is waiting. It's going to get punted into it. The person I feel most sorry for is Gordon Brown. I think he actually felt that he was going to be listened to this time and that they were going to be sincere about taking forward his agenda. We were promised almost federalism after the Scottish independence referendum, and instead of that we're getting our Parliament attacked day by day, government by government, backbencher by backbencher. Let's see if we could get back to this almost federalism. Let's see if we could get a degree of ambition from this government. It might be their backbench will hold them to account. I certainly hope that's going to be the case. They will find willing allies with us in order to try and achieve that. But this is an absolute mouse of a bill. It could be made better by accepting and voting for my amendments tonight, and I encourage the House to do so.
Nobody else on the government. Richard Baker.
Thank you, Madam Chair. It's a long afternoon, and it's a pleasure to serve under your chairship. And can I say how much I enjoyed, as I always enjoy, the witty and skillful speech by the member for Perth and Kinross-shire, perhaps firing an early starting gun on his own campaign for election to elected second chamber, given that the tap on the shoulder won't come for him. Although his party will have to do somewhat better, I think, if he's going to stand a good chance, given that he is here on his own. He spoke about donations for peerages, and we can only wonder what the SNP would do with £1 million donation, but perhaps Police Scotland actually know by now, given their investigations into these matters. But we have been also talking about delivery on constitutional reform. And the point that I made to the honourable member is this side of the House which has been delivering on constitutional reform, and we delivered in constitutional reform. And when we look at the fact that we have parliaments, and I might say, for all the talk from the Scottish National Party about reforming chambers, I served in Holyrood for 3 terms. I can tell you that's a chamber which is in great need of constitutional reform and reform its practices, and nothing has happened there at all. But here, in this place, within our first 5 months in government, we are bringing forward a significant and important piece of constitutional reform. And yes, I absolutely agree, Madam Chair. We want to see a faster pace of constitutional reform in this Parliament. But let us be clear about the proposal we have before us today. In 1997, we set out that this, as an initial self-contained reform, not dependent on further reform in the future, the right of hereditary peers to sit and vote in the House of Lords will be ended by statute. And that is what we are here to deliver this evening. Of course, as the Minister said, this is long overdue, and this is why we brought it forward so early in this government. It's also the case that it's important, it's a standalone reform, so we can progress it with the utmost urgency. And I think the member for Stoke Central was absolutely right about this, that in taking this forward, this as a standalone reform, we give it the best chance of progressing quickly, which is what we need it to do. I'm very happy to give way to my honourable friend.
Thank you, Madam Chair. I'm grateful to my honourable friend. I think he's making an excellent point. Returning to the substance of today's debate, surely there should be agreement across the House that this is a very long overdue reform, very, very long overdue. And my honourable friend is making an excellent point, explaining this clearly and succinctly to colleagues today. And I do hope that people will be mindful of that and ignore some of the more outlandish suggestions from the last member who spoke.
This is a fundamental issue of principle, and it's important. And it's important that we recognise in this House that the presence of the hereditary principle within our second chamber is outdated and is indefensible. And as other members on this side have pointed out rightly, the UK, I will go away in one moment to the right honourable member. The UK is one of only 2 countries that still have the hereditary element in legislatures. It is simply not before time that we are considering this legislation before the House. I'll give way to the honourable.
I thank the honourable gentleman for giving way, and I think he makes an important point about how difficult it is to defend the hereditary principle for legislators. But how does he go about defending the principle of English bishops being legislators
in Glenrothes and Mid-Fife?
It's interesting. Thank you, Madam Chair. It's interesting. We do actually have a former General Moderator of the Church of Scotland within that legislature, but we're within the House of Lords. But I do find it interesting. I very much enjoyed the speech by the Right Honourable Gentleman, and his points were made very passionately and obviously with great conviction. But after all, his party was in government as a majority government for many years and did nothing specifically on that particular issue. And I will certainly give way to my honourable friend.
My honourable friend from Glenrothes is making an excellent point. Not only were they a majority government in this place, they had a majority, or they had a plurality in the other place, so they were unfettered in their attempts. And did he accept that, whilst well-meaning as the argument may be from the honourable gentleman from Stonegate, Wyrley and Penkridge, to bolt on a non-manifesto commitment to a manifesto commitment risks derailing the bill that has already all but been agreed for the Salisbury Convention by the Minister at the dispatch box, and therefore risks losing all forms of reform that we're offering?
I think my honourable friend makes an excellent point, which I could not agree more. Risk derailing the bill and derailing the potential to have urgent progress on this particular issue, which it's so important we deal with as a House this evening. And as other members have said, I want to make this point very clearly. In making the case for this reform, it's about principle and it isn't about personalities. Through my own career before this House, taking up my seat in this House, I have received support and assistance of hereditary members in the House of Lords in many campaigns, a whole range of matters of public policy, and I have valued that support. And since my election, Madam Chair, I've had the opportunity to speak with hereditary peers who have brought significant experience to the House of Lords and who have been diligent and committed in their role and have clearly greatly valued their role in the House. But nevertheless, it is clearly the case that the membership of the House of Lords in advance of further reforms of the House should be based on experience and expertise and not by birthright. And given it also remains the case that there are no female hereditary peers, this is another example of how this approach to membership of the House of Lords cannot align with what I believe should be a shared goal to make the House more inclusive and representative of wider society. And we heard some contributions earlier in the debate that making this move would somehow jeopardise the work of the House of Lords or reduce its effectiveness. I mean, after all, there will still be over 700 peers left. I don't think we're in danger of entering a shortage of peers in this Parliament. So I believe that this is a reform which must be taken forward now. And having recently joined the Public Administration and Constitutional Affairs Committee, I do look forward to further deliberation on reform of our second chamber. And turning again to the speech by the member for Perth and Kinross-shire, I am pleased to hear him, and not always been the case, the speeches he's made, Lord Gordon Brown, whose I believe that Gordon Brown's leadership of the Commission on the UK's future, established by Labour Party in opposition, was an extremely important and vital contribution to the debate on how we take forward the constitutional arrangements for government in our country. And I do hope, and I would say to the honourable member, this absolutely needs to be an active document in this Parliament and discussed in this chamber, and I hope by the Select Committee I've just joined as well, when we look forward to the future of our constitutional arrangements, because the report is right to set out a proposal for a Council of Nations and Regions, and it shows also the necessity for reform in regard to hereditary peers, and why those wider reforms in the House of Lords will also be important in relation to public confidence in our institutions of government. Because that report highlighted research showing that 71% of people in the UK back overhauling the House of Lords. And that support cuts across parties and it cuts across nations and regions, and nearly half of the British public thinks the Lords does not work well. Support for the current composition of a second chamber was reported in the Commission's report at just 12%. I believe the member for my honourable friend from Bolton West found that actually support is recorded in even lower levels in some other research. And this shows why this reform is so desperately required if we are to attain confidence in our second chamber. And we also have analysis which shows the majority of the House of Lords are based in London and the South East. And if we want to also increase confidence in this Parliament, in Westminster, that is an issue which has to be addressed along with further devolution to other parts of the United Kingdom and the nations of the United Kingdom as well. And a second chamber whose membership is far more reflective of all the nations and regions of the UK can only help generate greater confidence in our legislature in every part of the country. I'd be very happy to give way to
the Honourable Member for giving way. Interested in, he cites the Gordon Brown study, which one of Gordon Brown's allies told me had just gone too far and therefore was not acceptable to the front bench opposite. But on this issue of representation of the Lords, from further away, from less advantaged people, to achieve that sort of balance that you described, you'd have to salary the Lords, wouldn't you? Because it's very hard to provide for a second home or accommodation in London on £300 a day.
I think there have been many ways to achieve the kind of balance of representation which I've spoken about, and quite rightly. And the Right Honourable Member has shown he's very passionate on these issues too. I would hope he would want to participate in further debates which will go much more broadly into the issue of reform of the second chamber, and we will have the opportunity to have those debates and the discussion over the course of the next 5 years. And so those opportunities, I'm absolutely sure, will be there. But I think, regrettably, we have to also reflect on the fact that why is public confidence in the second chamber so low? Why is it people lost faith in our second chamber? And I have to say it's because of the actions of the previous government, which have so, in effect, reduced and blighted reputation of second house, that this is why this, along with other reforms, is so desperately needed, because this issue of public confidence is absolutely crucial. And too often, despite the best efforts of the Speaker, the members of this House, the members of the House of Lords themselves and the parliamentary authorities, our constituents feel detached and remote from their Parliament as a whole. And I want my constituents in Glenrothes and Mid-Fife and all those who we represent in this House to have confidence in this Parliament and our democratic structures as effective and connected to them and their communities. And I'm sure this is an ambition which we all share. So, of course, there is much further to go, but I very much welcome that we are finally addressing and concluding this issue of hereditary peers as members of the House of Lords. It is a very important step on the journey of much-needed reform of our second chamber.
Sir Ashley Fox.
Thank you, Madam Chair. The Labour Party promised immediate reform of the House of Lords in its manifesto, and it set out a number of steps that it was going to take. But what they've done today, what they've brought forward, is just one of those steps. And it's the step that is the most convenient politically for them. Is it a coincidence that the government has brought forward a proposal that removes 84 hereditaries that don't take the Labour whip? No. And yet they seem reluctant to take those other steps. It seems very few people on the benches opposite that really want the 26 bishops to stay, yet perhaps it's convenient that when the bishops do turn up, they more often than not vote with the party opposite. So our objection, my objection to this bill, is that I have a real fear that there is no second stage. I think the member for Perth and Kinross-shire is absolutely right. It'll be this bill and nothing else for the rest of this Parliament. And members opposite will wait in vain for that second stage. Because that is what happened when the Blair government tried to reform. We were assured that the 92 hereditaries would remain as a permanent reminder of the need for proper reform. And now what the party opposite are doing is removing the hereditaries, but not making clear what the further proposals are or the timescale. So, Madam Chair, that is why I brought forward my Amendment 24, a new clause 19. The intention behind that was that commencement of this bill would be paused unless and until the government brought forward legislative proposals for second stage reform. Now, in fact, my honourable friend for Brentwood and Ongar, his Amendment 25, actually does one better than my Amendment 24, so I'm happy to withdraw Amendment 24. I will instead vote in favour of Amendment 25. But I think the intention is clear. It provides the guarantee that proper reform will be brought forward. It provides an opportunity to reflect on the type of upper house we have. I think we should have a smaller upper house. I think the upper house should be wholly or largely appointed. It should not act as a rival to this place. And I think Liberal Democrats that talk about their desire for an elected second chamber don't fully understand what they're getting themselves in for. Look, for example, at the United States, where you sometimes have the two chambers commanded by different parties, and very little happens at all. Now, a country with an executive presidential system can get away with that. A parliamentary democracy could not function where you had a government with a majority in this chamber permanently blocked by elected upper house. I think my honourable friend for Stone, Great Wyrley and Penkridge has brought forward a number of amendments which help enact the Labour Party manifesto, a retirement age, participation rates and other features that would make the upper house better. So, Madam Chairman, I will conclude. I will support Amendment 25 tonight, and I commend that to the House.
Sir John Hayes.
Thank you, Madam Speaker. Last time we debated this issue, I talked about legitimacy and continuity and dignity. And nothing I've heard tonight refutes the arguments I made then. Of course it's true that this House's authority is drawn from the democratic legitimacy which enables each of us to speak for our constituents, chosen by them and answerable to them. That's not the only form of legitimacy. When I heard the Liberal Democrats spokesman offer her views on this subject, I was minded to say, well, where do you stand on the head of state? Our sovereign is chosen by birth, not by election. And the head of state is critical at the apex of our constitution. After all, as I pointed out last time, the honourable gentleman on the front bench, for whom I have great regard, as he knows, was appointed by His Majesty the King, as I was during my time as a government minister. I'm going to give way to the honourable gentleman from Bolton West, who's edging towards the edge of his seat. I gave his speech 4 out of 10, his contribution, 2 for energy, 1 for enthusiasm, and 1 for content. But let's see what happens.
Exactly.
I'd like to thank the right honourable member for giving way. Does he agree with me, however, that there is a clear distinction between having a monarch who is a constitutional sovereign and who does not withhold royal assent through the legislative process, as opposed to hereditary peers who are legislating in the other place on a daily basis?
I'm going to try and be helpful to the honourable gentleman. He's a new member of this House, and we all learn something every day here. And when you've been here for 27 years, unless you're entirely stupid, you've learned a great deal. And so I picked up 1 or 2 things. And the critical point in his argument, the critical frailty in his argument, is the difference between authority and influence. Of course it's true the King grants royal assent to the bills that we pass, and so they become acts. But the very business of him granting royal assent reinforces his authority, and the fact that he has a personal audience with the Prime Minister on a weekly basis, which is more than the honourable gentleman ever will, and more than I do, suggests that his influence over our affairs is considerably greater than most of the people elected here. So it is quite wrong to suggest that the monarch doesn't exercise political influence and thereby political authority. I also spoke about continuity, the importance in our constitutional settlement. of the continuation of the role of the House of Lords provides a degree of continuity. People have talked about what's time-honoured and cast that aside as though it doesn't matter. What's time-honoured counts, because what's time-honoured has been honed by generations of people, not merely decided upon by one group of people at one point in time. And I heard another speech which criticised birthright. If I stood here and said it was the birthright of every Briton that habeas corpus prevails, if I said that it was the birthright of every subject of this kingdom that they can speak and think and act freely, everyone would feel that it was entirely right and proper for me to make those pronouncements. Yet birthright has been criticised in this chamber as if it was as nothing. The Honourable Lady.
Thank you, Madam Chair. And I thank the Honourable Member for taking the intervention. I think the point about birthright is that the birthrights that he describes are available to all of us.
Yes.
The birthrights that we are talking about with regard to hereditary peers are restricted to very few people, some of whom have inherited them from a point in history that is literally in the history books and is so far back, and the contribution is so archaic now that it really means nothing. So we have to be realistic about this, and that is why we're looking at the hereditary peers first of all.
Well, some of the things which we inherit by birth are indeed, as she describes, universal. Universal in the sense that all Britons enjoy them. Of course, they're not universal in the sense that those across the world enjoy them. They would love to enjoy many of the freedoms that we have earned over time due to those that came before us. As you said, these things do go right back. The evolution of our constitutional settlement is rooted in history, shaped over time, evolves, and it's right that the House of Lords evolves too. And so I'm not against reforms of the House of Lords per se. There is a case, for example, for saying that attendance matters in the House of Lords. We don't have an amendment to this effect, but it would be perfectly reasonable to say that if you're appointed to the House of Lords as a life peer, but you never attend, or you attend very rarely, that you give up your right to do so. That would seem to me to be a perfectly reasonable, a measured reform of the House of Lords. It would cut the numbers dramatically, because although we're frequently told the House of Lords has many, many hundred members, if you look at those who regularly vote in divisions, they tend to be drawn from the same group on both sides of that chamber. So there are sensible reforms that can be made to the House of Lords. But this reform neither delivers in terms of legitimacy, for it makes the House of Lords no more democratic, nor in terms of efficacy, because it makes the House of Lords no more effective. One is tempted, therefore, to assume that it's prejudice dressed with spite that lies behind this proposal, and I find that hard to believe, given the high opinion in which I have for the two ministers sitting on the front bench. Now, there are many of my newer parliamentary opponents, I would never say enemies, of course, who want to intervene. I'll take this gentleman on the... Shall I take them in order? On the right first.
Thank you, Madam Chair. Now, the honourable gentleman was keen to score, I believe, my honourable friend, the right honourable gentleman, apologies, was keen to score my honourable friend, the honourable member for Bolton West. I think he was a little unfair. I think he gave him 4 out of 10. Rather unfair. Significantly higher, let's put it that way. Significant, it's 8 or 9, I'd say. 8 or 9. You know, but if I may, I would suggest that honourable and right honourable members opposite, I would give them between 7 and 10 out of 10 for being patronising.
I don't mean to patronise the honourable gentleman. I was being paternal rather than patronising. Avuncular in the way that I dealt with the honourable gentleman. It's a known fact, proved by events, that I've tended to encourage new members to this House, perhaps to a greater degree than many other senior members, and that includes members from across the House, as is well known. And I say one more thing. One of the things that one learns here, and I spoke about the learning curve which we all face, is the relationships that pervade across this House are as important as the relationships you form on your own benches. I give way to the Honourable Gentleman.
I've been here a little while, 7 years, and the Right Honourable Member for South Holland, the Deepings, hasn't ever encouraged me, although he has scolded me once or twice. But actually, in his speeches, talked about democracy, a number of occasions regarding democratic reforms. Democracy, emanates from Athens, from the Greek Republic. That is where the origin is, of demos. And what does demos mean? It means the common people. And exactly, we are talking today about giving common people the right to sit, not the uncommon people of the hereditary peerage. And that is the point that we're talking about. Demos is for universal rights for everyone, not for a select few.
You won't allow me to go into immense detail about Athenian democracy, although I did study ancient philosophy. But what the Honourable Gentleman will know is that Athenian democracy was very far from the democratic principles that we hold dear. Only citizens had the vote in Athens, and the assembly there was a very partial affair, and certainly wouldn't satisfy you, Madam Deputy Speaker, nor other members of this House. But let me return to the subject in hand, and for a few moments before I give way to the Honourable Gentleman. Having made the case that this doesn't afford greater legitimacy or efficacy, I want to speak about authority. The authority of this place, the authority of the Constitution, and the authority of government. The authority of this place, as the member for Bolton and others argued, essentially derives from the fact that we are elected. But it doesn't just derive from that. It derives in part from the balance in the relationship between this House and the other House. Bicameral systems which pitch democratic chambers one against the other often are less successful than the model which has evolved in this country, where the upper house, though it sometimes chastises this House, certainly scrutinises us, although in its role as a reforming chamber, it might clash occasionally with this House, in the end defers to the elected House. And a bicameral system born of two Houses of Parliament, one of which is elected and one of which is not, seems to me to be more desirable for that very reason. You do not have competing democratic legitimacies between the House of Commons and the House of Lords, which is why I disagree with the amendments in the name of some of the members on my House and why I disagree with the honourable member from Kinross and Perthshire.
The Right Honourable Gentleman's been very generous with taking interventions. I'll just to boil this right down, though, Madam Deputy Speaker. This government was elected on a mandate to remove the hereditary peers from the House of Lords, not talking about setting up a wholly elected House and the concerns that he's talking about right now. Does he support the government's mandate and legitimacy to remove those hereditary peers?
Well, the government's mandate was slightly wider than that. It was a more widespread reform of the House of Lords. And I won't go into it again, but the manifesto of the victorious party's reelection that now forms the government suggested a whole range of measures to reform the House of Lords. I don't really approve of any of them, those measures. I don't believe in an elected second chamber. I've already made that very clear in my last remarks. And I take the straightforward view that the system at the moment, for the most part, by and large, works pretty well. I think you could make reforms. You can certainly look at how peers are appointed. That seems to be a perfectly reasonable thing to do. You can look at the number of peers in the upper house, as I've also mentioned a moment ago. But I don't really buy those reforms. And as far as mandates are concerned, certainly the government had a mandate to bring that package forward, but the official opposition has a role in both countering that and ultimately opposing it. That's the nature of our parliamentary system. If my goodness, if we voted for everything that was in the Labour manifesto that the Labour government therefore brought forward, there'd be no point in having an official opposition of any kind. I will give way one more time to Ellie and give her a second bite of the cherry.
Thank you, Madam Chair, and I'm very grateful to my honourable friend for taking the intervention. I struggle to understand, however, what the Conservative Party's line on this particular bill is going to be this afternoon. It would appear the honourable gentleman disagrees with a number of his own colleagues. So at the end of the day, how are his benches going to vote?
That's a matter for those on the front bench. I see here members of the Conservative Whip's office. I see my honourable friend sitting behind the matchbox. I, these days, am merely a highly regarded, distinguished and senior backbencher. The days when I had any say in how the Conservative opposition, or indeed in previous times the Conservative government, chose to vote on divisions are gone, but not gone forever. This is only a sojourn on the backbenches. I just want to make that perfectly clear. I want to also, when we return to my principal theme, which is one of authority. The authority of this House, as I said, is partly born of its relationship with the other House. Were the other House to become elected, by definition, its authority would grow, and our authority, in comparison, would diminish. And so I am strongly opposed to a elected second chamber. Whilst I accept the honourable gentleman's principled argument and the principal argument of others, that's not for me. There's also a matter of the authority of our Constitution. Our constitutional settlement, and we've rehearsed this briefly in this debate, is dependent on that relationship, but also, I think, it's fair to say, on reforms of these kinds being measured. Now, it might surprise members of the House that last night I was looking at a short book written by Hilaire Belloc and Chesterton. And that book, which is available from the Library of the House, rehearsed the arguments that pervaded at the time the Parliament Act, then the Parliament Bill, was debated in the House of Commons. And it may surprise right honourable and honourable members to learn, I learned it last night, that when Asquith introduced those changes, when the House of Lords, as you remember, rejected Lloyd George's budget, and therefore it became necessary to curb the powers of the House, rather than rushing to legislate, Asquith set up a conference between both sides of the House in order to determine a compromise. Now, whether Belloc makes the point, of course, Belloc was elected as a Liberal MP, as you remember. Belloc parodies that process, by the way, and said that what came out of it was no better than what went into it. But nonetheless, it was an attempt, at least, to reach a settlement in a dignified way as to how we might reform the second chamber. And I just well, it did take two elections. To the 1906 elections, the honourable gentleman and the Liberals had a very... and that's true enough. I wonder if the honourable gentleman wants to intervene on me, just to sharpen up the history.
Well, the particular Constitutional Convention did not produce a consensus. It took two general elections in 1910, one in January, one in December.
That's precisely right. So the first general election, there was an assumption that the government would proceed. The Constitutional Conference did not produce an outcome that brought about a reform that both sides could agree, and then a further general election followed. And the honourable gentleman rehearses exactly what that short book describes. But the point was that even Asquith, at that time, determined to reform the House of Lords, felt that ideally that reform should be on the basis of some kind of consensus, or at least a conversation about how that reform might happen and what shape it might take. And that's important because of the authority of our Constitution, to some degree depending on its dignity. Finally, I want to talk about the authority of government. We talked about mandates. Of course, it was long ago that the term elective dictatorship was first used. And the nature of this place, the nature of the relationship I described earlier between government and opposition, but also between different sides of this chamber, is an important way of countering the risk of a government with a very large majority ignoring counter-argument, becoming, I hesitate to use the word corrupted, altered, changed, distorted by the scale of his majority. Because frankly, in this Parliament, the party opposite will be able to legislate as they choose at any and every turn. And I will give way in 1 second. As experienced members of this House know, including the Treasury bench, government is better when it needs to compromise, it needs to reach agreements, it needs to consider amendments. When I was a minister, many times in bill committees in particular, the shadow minister would table an amendment. And of course, I routinely, systematically have the argument and then make sure that the amendment was voted down. But I would often go back to my civil servants and say, well, I think that was rather a good argument. Why aren't we doing that? I think he or her was right. We ought to alter the bill. And I would then engage with the shadow minister privately and look at ways in which we could improve the legislation through that kind of scrutiny. And good ministers and good shadow ministers have always worked in that way, as I did with the now Prime Minister when he shadowed me when I was Security Minister. And governments need, therefore, to understand that to alter your position through that kind of exchange and consideration improves the exercise of government and adds to government's authority rather than subtracting from it. Good governments behave in a way that, rather than taking advantage of their power, mitigate their power by the choices they make. And now there was an honourable gentleman who wanted to intervene.
I thank the right honourable gentleman for giving way, and I think he makes a very important point about the need to govern responsibly and reasonably, whatever one's majority. I was interested, actually, while I was sat here, in the right honourable gentleman's record of following through on that strong belief. And so I googled his name in the word prorogation, and I didn't see any mentions. I wonder if the honourable gentleman could reflect perhaps on recent governments and any points when he thinks that they might have abused their power.
What I found when I was a shadow minister for many years was that some of the Labour ministers I shadowed did the job I just described very well, and some didn't. And when I became a minister, I saw that some Conservative ministers engaged in the kind of process I described, and some didn't. So the truth is that there's always been a variability in the way that power has been exercised across political parties. And I would invite him to speak to any of the people who shadowed me when I was a minister to see if they would validate how I described what I did and the way I acted in those days. So authority of Parliament, authority of our Constitution and authority of government are all at stake as we consider these matters. I return to where I started in terms of efficacy. Now, last time I was considering these matters, I quoted Proust, you'll remember, and it was a bit too rich a diet. You'll remember Kinross. He's not a Proustian. I think it stretched the canon of his reading matter beyond breaking point. So today I'm going to test him a little more and just refer to Chesterton, G.K. Chesterton, who I think might be more within his scope. Well, he's kind of, from a central position, kind of acknowledging that. And Chesterton said, to have a right to do a thing is not at all the same as being right in doing it. It's certainly true that based on their mandate, the government have the right to bring this legislation, but I'm not sure they're right in doing it, measured against my tests of dignity and legitimacy and continuity and authority. Whereas Chesterton also said, before you take a fence down, you consider why it was put up in the first place. And the balance that exists at the moment, both within the House of Lords and between the House of Lords and this House, is precious. It works. It ain't broke, and we don't need to fix it.
Yeah.
Before I finish,
I thought you were finishing, John.
Before I finish, let me say this to my honourable friend.
The end of my opening remarks.
We must vote against this bill on third reading, because whether you're in favour of more reform, as some of my colleagues are, or no reform, this bill doesn't meet the standards you would expect of good legislation. And it's vitally important, therefore, that the official opposition make their position crystal clear by opposing this undesirable and unnecessary legislation.
Brian Leishman.
Thank you very much, Madam Chair. And for the record, when we talk about more reform, it is with a lowercase r. For many people, the other place in its current format embodies what Britain really shouldn't be. Undemocratic, unelected, and to only very lightly touch on this, it's seen its fair share of controversial appointments. A suggestion of nepotism here, a dash of financial scandal there, not to mention a sprinkling of oligarchy. Therefore, it represents what a classist society of haves and have-nots can produce. And as we know, some members are there on a hereditary basis, some on the whim and wishes of political leaders who, of course, have their own political motives for having them in position. And it's also clear that the different regions that make up the United Kingdom don't have fair representation. And the other place doesn't just have a geographical imbalance, but also a gender one, none of which I care for. I do believe that there should be an upper chamber. Certainly in Scotland we have seen some ill-thought-out political policy that has been financially costly. An upper chamber would likely have prevented that with the benefit of added scrutiny. So, to finish on, Madam Chair, like British society, the other place needs transformational change. And what the government propose is only a step in the right direction to what I, as a Labour Party member, will continue to campaign for from within the party, and that is to ultimately change the other place into an elected chamber where class and privilege is not the entry requirement, but talent and ability is what gets you there.
Sir Edward Lee.
It's an honour to follow my right honourable friend on this side of the House, such a well-loved, distinguished, senior member, even if he only has served 27 years in this House. I've sat through all this debate and I wasn't intending to speak, but I just want to reply to a few comments, because by its very nature this debate has been confrontational. That's what we do in this place, and we tend to concentrate on what divides us rather than what unites us. So I just want to say something about what might unite us. And first of all, these ideas that divide us. First of all, we're debating whether we should abolish the hereditaries, and the Labour Party says it's in our manifesto and therefore we can do what we want, and we say that this is gerrymandering, and the bulk of these people are hard-working and by nature they're conservative, so this is an excuse to get rid of a large number of conservative peers. So we say that, the government is going to carry on and do it anyway, so that's clearly very controversial. And then the next proposal apparently is to abolish the bishops, and I've heard what my right honourable friend says, but there are all sorts of objections to doing that, not least that this is an established church. Do we really want to attack a faith community? It's part of our history. Are they really doing much harm in the House of Lords? By the way, the Catholic bishops don't want to, because of our canon law, don't want to be a member of the House of Lords anyway, although apparently they're quite willing to support distinguished laymen to help the Catholic cause of the House of Lords, but we all know that. So I don't think we're ever going to get to an agreement on abolishing the bishops in the House of Lords. As regards age, we've had this debate. Again, we can't agree on that. It was a point I made earlier. There are so many people up there who make a tremendous contribution in their 80s, and the Prime Minister just appointed a distinguished former Foreign Secretary, Chairman of the Public Accounts Committee from this place, who are 80, and he presumably did that not thinking that they were going to have to retire immediately. So there's no consensus on age either. There's no consensus on whether it should be elected. We've had this debate for 120 years now. Some people, like the Liberal Party, say that it's ridiculous that you should have an appointed parliament, that the only proper way of doing this is to have elected people, and then we remind them that you just leads to gridlock. This is a parliamentary democracy, not a presidential system. So there's no consensus on any of these issues. But there is, and this is the point I really want to make, there is consensus on one issue, that the House of Lords is too large. There are 805, members of the House of Lords, the second largest chamber in the world after the Supreme Parliament of the People's Republic of China. There is consensus around that. So we should perhaps reduce the size of the House of Lords. And there is a simple way to doing this, surely. Given that of 150, apparently, members of the House of Lords are not very interested in turning up very often, or even at all, some of them, why don't we simply ask all the different groups in the House of Lords, hereditaries, bishops, life peers, and all the different parties to reduce their membership by a similar percentage, so there's no accusation of gerrymandering, and we reduce the House of Lords to around 600 members. This can be done very simply, given that so many people are quite happy to have a peerage but don't want to turn up. It could be by election. These groups themselves could decide, not the government, no question of gerrymandering. They know who works hard, they know who turns up. Probably wouldn't even need election. And we could reduce the House of Lords by this simple device to around 600. We could do it immediately, and we could ensure that all those people, perhaps who shouldn't be there, who are appointed for the wrong reasons, would leave that place. And we could do that very simply and easily. We could do it by consensus. And we could also beef up the Appointments Commission. The moment they can reject somebody on grounds of propriety, but they can't reject somebody on the grounds of suitability. And the powers of the Appointments Commission should be beefed up to ensure that only the very best people are appointed to the House of Lords, the people who have got experience, who can make a proper contribution. And there's no question, just to please my friend from the SNP, of appointing donors and cronies to the other place. These two simple reforms could solve this problem. We've heard about constitutional conferences in the past. I just put this idea to the Paymaster General, who I respect greatly, that perhaps it wouldn't be a bad idea for the political leaderships of all these parties, of all our parties, to sit down together and to do such a reform, to reduce the House of Lords to around 600. And whether we really in future want to appoint people in life, yes, I'll make my point. Whether we want to appoint people for life, why don't we just appoint them for 15 years and they retire in the general election after they've done 15 years? All these things are very moderate, very sensible ideas, and we could get consensus on it. We could reduce the size of the House of Lords, we could get rid of the bad apples, and we could actually achieve what we want. I give way to my honourable friend.
Does the Father of the House agree that inevitably we've been talking more about the process, given the nature of the bill, by which people become members of the House of Lords, than the activity which it carries out? And in particular, although not everybody in the House of Lords is an expert, a large number of people are experts, people who have reached the top of their respective professions, whether it be academia, the law, the arts, the judiciary, whatever. And does he cast his, or can he cast his mind back to 1984, when he and I, who had both fought the 1983 election, him for Gainsborough and Horncastle, which is why he was in this house, and I for Swansea West, which is why I was not, cooperated on trying to reform trade union elections to have postal ballots for trade union elections. And does he remember how he introduced a bill in this house, but it got nowhere because of the strong whipping of the system of elected members? But when we took it to the House of Lords, we were able to persuade people on the arguments because of the light whipping. The amendment went through there, and when it came back to the Commons, the then government brought in its own measures to meet the point. So does he not agree that an elected second chamber, apart from creating gridlock, would not have the possibility of introducing fresh ideas which, once introduced, may be accepted by a government in this place, which would never get off the starting blocks if introduced in this place initially?
Well, that's a very good point. I remember that rebellion very well. It was the start of my many rebellions. I do suggest the honourable gentleman opposite, they don't rebel, actually. They want to get on to this place. But we did have that rebellion. We finally won that issue. And my right honourable friend makes a very good point about how we did win the argument. And it just underlines how important it is to have a second chamber which is not composed of elected politicians. I really don't see the point. It would just be like this place. It would be full of people who want to become ministers, who are completely subordinate to the whips. What is the point of having an elected second chamber? The whole point of a second chamber is it should be independent-minded, and they are independent-minded. They regularly defeat the government, and they actually have better debates than we do. They're full of people who have tremendous experience in the professions, in business, in charities. So, I mean, I just don't see the point of getting rid of them, lock, stock and barrel. But I do think there's and this is why, just make my point, there's a perfectly good consensual argument which says that the numbers should be reduced, and there are some people there, either by the fact that they've been appointed not in an entirely right way, or because they don't turn up, who we should remove. I give way to my right honourable friend.
Further to the point made by my right honourable friend, Bagot spoke about this. So what Bagot said is that the distinguishing feature of the House of Lords is their view is emphatically their own view. And in his terms, and you'll understand what he meant, they're subject to no social bribe. Well, which he meant they weren't answerable to the constituents the way we are, and therefore subject to the pressure from constituents. They could make a judgment entirely free of that. That is a virtue of the current arrangements, and frankly, a virtue of the hereditary peerage too.
Yeah, but I think we can all agree on that actually the other place, for all that it is seemingly undemocratic, actually works quite well. They actually do listen to the debate. They vote according to their conscience. They have said that they regularly defeat the government. They improve bills again and again. So, you know, if it works, why change it? So I'll just sit down now and I just say to the Paymaster General, could you please think about the idea that I've suggested, that we could get some sort of compromise by which all parties in the House of Lords are reduced by the same amount. We reduce it to around 600. We give more power to the Appointments Commission, and in future we keep it at about 600.
Dr. Andrew Murison.
Grateful, Madam Deputy Chair. Can I say that I'm very much attracted by the argument laid out by the Leader of the House. He's right to say that consensus in these sorts of matters is nigh on impossible, as poor Jack Straw found out in 2007. And he's right also, I think, to aim for a reductionist strategy in trying to decide what we can possibly do to improve the situation that is going to get a majority consensus in this House. Difficult, though consensus most certainly is in these matters. Now, this debate has been characterised, if I may say, by some levity. That's okay, and that's a positive. And I think it probably reflects the fact that most of our constituents aren't usually seized by constitutional matters, which isn't to say that these matters are not important. Plainly, they are. The attendance here today isn't what one might expect, really, for a matter of this importance. And that probably reflects the fact that a few months ago, when we were all knocking on doors, this kind of thing really wasn't number one in people's concerns. But it remains important nevertheless. Now, I confess I have been on something of a journey since 2007, when, at that time, I was rather persuaded that the upper house ought to be elected. Well, I'm not anymore, because I've seen in the workings of this place how it's possible for this place ultimately to be challenged by a subordinate secondary chamber that is itself elected. And try as I may, I cannot work out how it's possible to avoid that kind of situation. This is the primary part of our legislature. That must remain the case. We must be unchallenged, but we do need checks and balances, which is precisely what the upper house is aimed at doing. Now, many have spoken today about who we might remove from the upper house, and I have no principal objection to the things that the government is trying to do. However, I'm persuaded that matters of this sort should be part of a wider package, which is why I, of course, will be supporting the opposition amendment today. However, I do think, my view is, that we probably got this round the wrong way, frankly, which is why I very much support the amendments being brought forward by my right honourable friend in relation to the bishops. I remember when I was pontificating in another country, a majority Muslim country that was a nascent democracy, on democracy. And at the end of my spiel, a lady, to her very great credit, put her hand up and said, "Listen very carefully to what you've said, but with the greatest of respect, who are you to come here and lecture us, given that you have within your legislature people who are there by dint of hereditary right, and people who are there because they are part of a particular religious persuasion." And, you know, we've heard some quotes today. G.K. Chesterton, I can't really match that one. I think I probably can. I've got Robert Burns, who said, "Want some power the gift he gives, to see ourselves as others see us." Now, I like that. What he's saying is it's important to note how we look to other people, to other countries, to other legislatures. And it seemed to me, in those words of that lady all those years ago, that she had the measure of it. We may not think we're a theocracy in the same way as Iran is, or indeed in the same way as Lesotho or Swaziland retain the hereditary principle, but we are, and we need to remedy that, because appearances matter, and that lady on that occasion was absolutely right, which is why I support my right honourable friend in his amendment, and I hope the government will reflect on that. I also agree with the honourable gentleman from Perth and Kinross-shire in his assertion that this is it. It's no good hoping for another bill. That bill is not going to come. If it does, there's no guarantee it's not going to end up in the same place as poor Jack Straw's measures ended up in 2007. Given the difficulty with consensus, I suspect that's exactly where such a measure would land. So this is it. I don't particularly want to see our legislature populated by people who are there because they are representative of one particular faith community in this country. I'm an Anglican, just like my right honourable friend. I'm a practising Anglican, and I value the views of bishops. Of course I do, but it's simply not right to have them being politicians in dog collars, I would say generally propagating a left liberal world view. I would much rather that they were in their diocese engaged in the cure of souls. That's where I want to see them as an Anglican. Now, this evening, I will certainly be supporting my front bench in their measured amendment. I hope very much the government will be listening very carefully to what has been said. These are grave, serious matters that need to be debated carefully and in a measured way. I see no virtue in ploughing ahead with this in this emergency way, but rather see virtue in incorporating it into a wider set of proposals to come back to this House with at some later stage. I hope not too late, but later nevertheless, so that we can consider these things in the round. And I very much hope we will be able to see those proposals, I live in hope, before too long. The party opposite has had 14 years to consider all this. my view is that this is it. It's disappointing and it's a missed opportunity.
Sir Julian Lewis.
Madam Deputy Chairman, it was not my original intention to speak, but in view of the nature of the debate that's taken place and a signal I've received that I might be given a little latitude to go slightly wider than the narrow terms of the bill, I would just like to make a single point in slight elaboration of the intervention I made upon the Father of the House a few minutes ago. A lot has been said about how the public are deemed to regard the status of the upper house. I'm not sure on what basis such sweeping statements have been made, although I can understand that when from time to time someone manifestly unfit or inappropriate to be ennobled is ennobled, that may cause a degree of public concern and disillusionment. What I would like to just set on record and particularly draw to the attention of new members on both sides of the House, but particularly on the government side of the House, is that they should avail themselves of opportunities to get to know more closely and to understand what it is the House of Lords actually can do that the House of Commons cannot. In the first instance, they can bring expertise to bear, which is not to say that the people who are experts, and they are not all experts in the House of Lords, but a lot of them are, as I said in my intervention, because they reach the top of their professions, it's not to say that they are necessarily any brighter, more intelligent, or more cultured than people in this House. But it is a fact that people in this House chose to divert themselves from whatever escalator they could have been on to become full-time politicians, and so we do not reach the giddy heights that other people do in other professions and are then able to bring to bear on the legislative process by being taken on board in the upper house. Before I continue, I'll give way to the honourable gentleman.
I appreciate the right honourable member is not a doctor, but I wonder if you could explain to me the biological process by which someone inherits expertise.
Sir Julian Lewis.
I'm not aware that anything I've said this afternoon has been in favour of retaining the hereditaries. It hasn't, and if he had listened to my earlier interventions, he would have known that was the case. I'm talking about and that's why I said I'm going somewhat wider than this bill, which is focusing solely on the hereditaries, that's why I'm saying that the suggestion that the upper house stands in low repute is ill-conceived. And the reason why I would urge him and other new members of the House to take advantage of the seminars that I and other members from his party and from the Liberal Democrat Party try to organise to enable new members on both sides of the House to be brought into contact with leading members of the upper house to see what they do would be a good use of his and other members' time. And so I will just wrap up my remarks by saying...
Before wraps up, I'm grateful friend, but the honourable gentleman is making a very important point, and it is about the subtlety of the relationship between the two houses. I spoke earlier about the relationship between government and opposition. In an unwritten constitution, political culture prevails, and that political culture is informed by that subtlety, by those relationships. And he's described an occasion where legislation emanated from an origin in the other place, but very often legislation is improved and perfected through that connection, and that should not be lost as we rush headlong into a piecemeal reform of the House of Lords.
The elements that make up the House of Lords consist of people, some of whom have got there by accident of birth and who are now going to leave, some of whom have got there as a result of political horse trading of some sort, and perhaps should not have been put there in the first place. But a great many have got there, as I said earlier on, through having reached the heights of their various professions and having proved themselves to be outstanding intellectuals who can bring a level of specialization to the scrutiny of legislation which we in this House cannot do, not least because even if we were exactly on their same level of accumulated knowledge, the demands that we have to face in terms of our time and in terms of looking after our constituents inevitably work to the cost of the amount of attention we could give purely to focusing on improving legislation. And so I just wish to place on record the fact that the reason why I became an ardent advocate of an unelected second chamber, and I would rather have no second chamber at all than 2 elected second chambers, the reason I became such an advocate of this unelected second chamber is precisely because it is impossible to whip it. It is impossible to prevent people with good ideas, if they can persuade peers of the virtue of those ideas, being able to have at least a sporting chance of amending legislation in good ways that would not get beyond first base in this House, because the elected members, for the most part, almost all of the time, obey the whipping. And as a result of that, I will just put on record that there were 4 pieces of legislation that I and my colleagues, when we were political activists, managed to get into law before I became an MP. Since I've been an MP, only 1 piece of legislation to do with the privacy of members' home addresses has got onto the statute book, because exceptionally that was a free vote. How many free votes happen in this House? Hardly any. The equivalent of free votes in the upper house happen all the time. Yeah. So we required postal ballots for trade union elections, and that was incorporated in the 1984 Trade Union Act and the 1988 Employment Act. We outlawed political indoctrination in schools, which was incorporated in the 1986 Education Act and carried forward in the 1996 Education Act. We prohibited local councils from publishing materials which promotes or opposes a point of view on a question of political controversy which is identifiable as the view of one political party and not of another, which was incorporated in Section 27 of the 1988 Local Government Act. And finally, we more strictly define the concept of due impartiality in the coverage of politically contentious issues on television and radio, which was incorporated in the 1990 Broadcasting Act. Every one of those measures was got through the House of Lords first, and then either adopted in the House of Commons directly, or the government brought forward its alternative proposals. You do away with the expertise of the House of Lords at your peril, because then all you get are machine politicians, whether they're in 1 elected house or 2 elected houses. And that is to the detriment of our democracy, not to its enhancement.
Iqbal Mohammed.
Thank you, Madam Chair. I am honoured to serve under your chairmanship. Before I begin with my prepared remarks, I just want to commend and pay tribute to my right honourable and honourable friends across the House for the oratory skills, the persuasion skills, the education and the entertainment. It's been an absolute privilege to hear people with such experience speak well informed on such topics. I also would like to highlight to my honourable friends across the House who are, like me, new members and are finding our feet and learning the ways of the world in this House. I'm pleased to hear that the new members are passionate about pushing and challenging their party to implement laws and changes that the constituents and the country demand. But I will remind them of the consequences. Rebellion, as I have seen in this short time, is rewarded with sanction or suspension. So it's better to get as much into this bill now as possible than to hope that you may ever get a chance to do that again.
Hear, hear.
Madam Chair, the House has been made aware, and I don't need to go into the details, that faith in political parties and institutions is at a low ebb, maybe the lowest in my lifetime. We've been told only 12% of the British public say they trust politicians. Trust politicians. Political parties are the least trusted of any UK public institution, and trust in Parliament is on the decline. Any measure which helps to rebuild that trust is to be supported, which is why I support the government's bill to remove hereditary peers. The anachronistic nature of hereditary peerage contributes not only to a sense of the House of Lords is out of touch, but all our political institutions are out of touch. It feeds a disconnect between the people and their systems of governance, and reinforces a belief that politics is the preserve of another elite, the political elite, that lives in its own bubble in Westminster. Because of the urgency to rebuild faith in politics and the need for radical change to that end, it is disappointing the government has chosen to be so timid in their ambition. I understand, and my fellow honourable members have said that they will try and push forward more changes, that they could introduce further changes down the road, maybe remove the over-80s from the Lords, or retire the 26 bishops who are automatically given a seat. The Lords themselves have raised the idea of removing those members who rarely, if ever, attend. But even these tame reforms appear to be too much for this government at this stage. We need much bolder action. I will give way.
Phil Brickell.
I'd like to thank the honourable member for giving way. Would he accept that this is the first immediate measure of modernisation of the other House, and that there are a number of other commitments that are enshrined in the manifesto of this government which will be seen to in due course through the course of this Parliament?
Iqbal Mohammed.
I thank the honourable member for his intervention. I do agree that it is a positive step, but it is the smallest of the steps that could have been taken by this government.
Absolutely.
And the promise of jam tomorrow is, as we know in this place, just a promise and hardly ever materialises. We need much bolder action now. It's bad enough we are alone in Europe in having a fully unelected second chamber. It is frankly ridiculous with over 800 members it is so large. To put that into some perspective, the US Senate has 100 elected members who serve a 6-year term. A third of the membership is elected every 2 years. The Canadian Senate has 105 members and a mandatory retirement age of 75. And the French Senate has 348 elected members who serve 6-year terms, half of whom are up for election every 3 years. The fact our second chamber has been allowed to balloon out of all proportion looks more sinister when you consider last year Lords appointees donated over £50 million to political parties. When it looks like our political institutions are up for grabs to the highest bidder with Jobs for Life, is it any wonder people see it as another private members' club? I welcome the amendments to the bill proposed by my right honourable and honourable friends examining alternative models to the House of Lords. It is not that difficult to imagine how we can improve on it. There should be no place for big party donors in any second chamber. It should have a fixed membership. The public should decide who has the right to populate it and be able to hold them accountable. And it should genuinely reflect the length and breadth of our country, unlike the current House of Lords, which is dominated by peers from the south and southeast.
I'm extremely grateful anyway. So you're making a case, it seems to me, for an elected second chamber. Does he imagine that chamber will be elected at the same time as this chamber? In which case it would be a duplicate, because the electors will vote different ways in the same day. Or is he suggesting that it's elected at a different time? In which case the chamber that was elected most recently would surely claim greater legitimacy and therefore greater authority.
Very good.
Iqbal Mohammed.
I thank the right honourable member for his intervention. He makes a very important point. I, as a new Member of Parliament, am not educated or informed enough to answer it immediately, and I would defer to the whole House to define how that process would work.
Would he give way?
Yes,
I'm very grateful, and I'm listening with the greatest respect and interest to what he has to say. Would he not then think there'll be virtue, merit, in having a unicameral system, a bit like the system, the sort of Plan B that my right honourable friend, the member for New Forest East, suggested, rather than having a competing elected upper house, because this is the primary chamber in our system.
I thank the honourable friend for his intervention, and again I will confess to my lack of knowledge on the detail around the alternative proposed by the member, and would defer to the House to select an appropriate working model that best represents the people of our country.
Will the honourable member give way?
Yes, please.
I think the honourable member makes a really powerful point about listening and having the best system. However, would he agree with me that having all the power located in one chamber and not having a division of powers as exists in other countries is something with merit and should be looked at? And also the principle of sovereignty, of course, differs under English law and in Scots law, and therefore we need to have a good and proper look about how our governance mechanisms.
Iqbal Mohammed.
I thank the honourable member for his point. It's a very important point, and I do agree that representation across the four nations is absolutely key, and the balance between the two houses and how they work together is also very, very important. Madam Chair, we have seen what happens when people feel alienated from their political system, how they can gravitate to those with divisive answers. Unaddressed political grievances combined with a lack of faith in political institutions can be a toxic combination. Reforming the House of Lords so it is fit and proper is not the sole solution to that problem, but is a key part of the solution. We in this House, as elected officials, have a duty to do the right thing at the right time, in the right way, to deliver the right outcome for our constituents and our country. And the right thing is to adopt the sensible and democratic amendments proposed by my right honourable and honourable friends, and the right time to do that is now.
Here.
Call the Minister, Ellie Reeves.
Thank you, Madam Chair, and I'm grateful to honourable members for taking the time to debate these issues in the House, and I've listened to the contributions with interest. I'm particularly grateful to my honourable friend, the member for Stoke-on-Trent Central, for providing a powerful voice in support of this important legislation, as well as other members on these benches. So too the honourable member for Richmond Park, who demonstrated when this bill received its second reading that there is a strong cross-party support for this first step in reforming the upper chamber. I'm also grateful to the right honourable member for Stone, Great Wyrley and Penkridge, who has taken a surprising interest in the issues that relate to this bill, and the honourable member for Perth and Kinross-shire. I want to stress that we are grateful to all peers, including hereditary peers, who have committed themselves to valuable public service. I'd like to reiterate that there is no block to hereditary peers coming back as life peers if their party wishes to nominate them. Madam Chair, what has become clear during the course of this debate is that the Conservatives do not have a coherent position in relation to House of Lords reform. It's not clear if the opposition front bench want to retain hereditary peers in the House of Lords or not. It is not clear if they want faster and further reform or not. It is not clear if they agree with the amendments tabled by the Right Honourable Member for Stone, Wyrley and Penkridge or not. But what is clear is that they can't agree amongst themselves on this bill. More division and chaos. I'll give way.
Thank you, Madam Deputy Speaker. The Minister will be aware that it's over 100 years since Keir Hardie committed to abolishing the House of Lords. So on the point of clarity, are we going to have to wait another 100 years for the Labour Party to get round to it?
We've taken an immediate first step, as set out in the manifesto, to remove hereditary peers from sitting in the House of Lords. The Honourable Member will know well that there are a number of other commitments in our manifesto which we are considering the best way to implement. It is right that we take the time to do that properly. Madam Chair, with your permission, I will now address the amendments tabled. New Clause 20, tabled by the Honourable Member for Brentwood and Ongar, seeks to provide a description of the purpose of the bill. Madam Chair, the Government cannot accept this amendment. The Honourable Member's explanatory statement for his amendment states, this new clause describes the purpose of the bill. Madam Chair, I'd be happy to clarify the purpose of this legislation for the benefit of the Honourable Member, which should be self-evident to anyone who has taken time to read the legislation. The bill is designed to remove the outdated and indefensible right for hereditary peers to sit and vote in the upper chamber. In 2024, there should be no place in our legislature reserved for individuals who are born into certain families. I would also add, Madam Chair, that the Honourable Member's amendment fails to take into account the presence of the Law Lords. Several such peers sit in the other place as members of the Lords Temporal under the Appellate Jurisdiction Act 1876 and make a valuable contribution to its proceedings. Therefore, the Honourable Member's amendment falls at the first hurdle. I therefore respectfully request the Honourable Member not press his amendment. I'll now turn to Amendment 25, also tabled by the Honourable Member for Brentwood and Ongar, which seeks to delay the implementation of this bill. Delaying the implementation goes against the Government's manifesto commitments. We were clear we would implement an immediate reform to the second chamber by removing the outdated and indefensible right for hereditary peers to sit and vote in the House of Lords. The Government set out a number of other commitments in its manifesto to reform the other place, and it's right that we take time to consider how best to implement these reforms. I therefore ask the Honourable Member not to press this amendment. I'll now turn to Amendments 8, 9 and New Clause 7, tabled by the Honourable Member for Richmond Park, which seek to impose a statutory duty on the Government to take forward proposals to secure a democratic mandate for the House of Lords via the introduction of democratically elected members. Although the Government agrees with the Honourable Member that the second chamber needs reforming, we cannot accept this amendment. This is a focused bill that delivers the Government's manifesto commitment to bring about an immediate reform by removing the right of the remaining hereditary peers to sit and vote in the House of Lords. The Government has committed to more fundamental reform through the establishment of an alternative second chamber that is more representative of the regions and nations of the UK. The Government will consult on proposals in order to provide an opportunity for the public to provide their views on how to ensure that this alternative chamber best serves them. Details of this will be set out in due course, and the House will no doubt take a close interest in this as it is taken forward. It is right that we take time to consider how best to implement the other manifesto commitments, including our commitment to consult on alternative second chamber, engaging with parliamentarians and the public where appropriate over the course of this Parliament. With this in mind, I ask that the honourable member does not press these amendments. I now turn to new clause 8, tabled by the honourable member for Richmond Park, and new clauses 9, 10 and 14, tabled by the honourable member for Perth and Kinross-shire, regarding the role of the House of Lords Appointments Commission in advising the Prime Minister on appointments to the other place. I thank the honourable members for their interest in reform of the House of Lords appointment process. I think we are all in agreement that it is vital that peers meet the high standard the public expects of them for the good functioning and reputation of the Second Chamber and Parliament more broadly. Constitutionally, it is for the Prime Minister, accountable to Parliament and the electorate, to make recommendations to the Sovereign on new peers. As part of its role, the House of Lords Appointments Commission advises the Prime Minister on the propriety of these nominations to the House. In this role, HOLAC considers whether a person is in good standing in the community in general and with the public regulatory authorities in particular, and whether the past conduct of the person would not reasonably be regarded as bringing the House of Lords into disrepute. The Prime Minister, of course, respects and values the Commission's advice and will place great weight on it when making decisions on peerage recommendations. The honourable members will be pleased to know that the Government's manifesto committed to improving the appointments process to ensure the quality of new appointments and to seek to improve the national and regional balance of the Second Chamber so that it better reflects the country it serves. The Government is actively considering how this can be achieved. The honourable member for Perth and Kinross-shire's new clause 14 removes the Prime Minister's role in advising the Sovereign on new appointments and hands this completely to the House of Lords Appointments Commission. This would be a significant change to the Commission's role and would require very careful consideration. This, however, is a focused bill that delivers the Government's manifesto commitment to bring about an immediate reform by removing the right of the remaining hereditary peers to sit and vote in the other place. I therefore respectfully request that the honourable members do not press their amendments. I now turn to new clauses 11 and 12, tabled by the honourable member for Perth and Kinross-shire, relating to members or prospective members of the other place who have made registered political loans or donations of over £11,180 since 2001. The Government believes the Second Chamber is enriched by members who bring diverse experience in support of the House of Lords' core functions of scrutinising legislation and holding the Government of the day to account. The House of Lords Appointments Commission is responsible for vetting all candidates for proprietary, and as part of this they consider party donations. I therefore respectfully ask the honourable member not to press this amendment. Turning to Amendment 15 and new clause 13, tabled by the honourable member for Perth and Kinross-shire, these amendments prevent individuals who are members of the House of Commons in the current or previous Parliament or in the previous 5 years to be appointed to or to remain as a member of the House of Lords. I should declare an interest that my husband, until recently the honourable member for Leighton and Wanstead, is now a member of the other place and also a government whip. This is recorded on the list of ministers' interests that was published last week. Madam Chair, I thank the honourable member for tabling these amendments. However, the Government cannot accept them. As I have said, the Government is supportive of the inclusion of individuals from all backgrounds and believes the other place is enriched by members who bring diverse experience. This, of course, includes former members of this place. There are valuable insights former members can bring to the other place, particularly with their previous experience of the scrutiny of legislation. Denying such eligibility for a specific time period would be unnecessary and prevent valuable contributions being made. I therefore ask the honourable member not to press his amendments. I will now speak to Amendments 1 and 2 with new clauses 1 and 2 tabled by the Right Honourable Member for Stone, Great Wyrley and Penkridge, which relate to the Lord's spiritual. New Clause 1 seeks to remove the Lord Spiritual from the House of Lords, with New Clause 2 and Amendments 1 and 2 consequential to the substantive clause. While I thank the Right Honourable Member for tabling this amendment and note the number of the signatures attached to it, the Government cannot accept it. This is a focused bill which delivers on a manifesto commitment to bring about immediate reform. The bill has the simple objective of removing the remaining 92 spaces reserved for hereditary peers from the House of Lords, thereby completing the process started in 1999. I've been very generous with my time in my opening, and we have had a full debate. Of course, the Government has committed to wider reforms to the other place, including establishing an alternative second chamber that is more representative of the regions and nations of the UK. The Government will consult on proposals seeking the input of the British public on how politics can best serve them. However, as I've set out, this bill is not the vehicle for considering wider changes. I therefore respectfully request that the Right Honourable Member does not press these amendments. Let me now turn to Amendments 3, 7 and New Clause 3, tabled again by the Right Honourable Member for Stone, Great Wyrley and Penkridge, regarding the introduction of a retirement age of 80 to members of the other place. I will go on to address Amendment 4 and New Clause 4, tabled again by the Right Honourable Member, which seeks to impose a participation requirement on all members of the House of Lords. The introduction of a retirement age or participation requirement is not the purpose of this bill. The Right Honourable Member, along with other members of the House, will be aware that the Government included a commitment in its manifesto to introduce a mandatory retirement age, where at the end of the Parliament in which a member reaches 80 years of age, they will be required to retire from the House of Lords. I'm also sure he is also fully aware that the Labour manifesto included a commitment to introduce a new participation requirement for peers. The House of Lords plays an important role in scrutinising legislation and holding the Government of the day to account, and the Government recognises the valuable contribution of many peers. It is important that all members participate in support of these core functions.
I thank the Honourable Lady for giving way. I mean, you know, what is being proposed in these clauses is very much what in the spirit of the Labour Party manifesto. I mean, I appreciate the fact that they're going to whip their party hard in order to be able to defeat their own manifesto and any sort of potential changes. But would she actually engage with me and other colleagues to actually how she could implement these changes as part of a bill in the other House going forward? Yeah. Because actually there is an appetite to see that change, and it's disappointing that actually, especially on the Lord Spiritual, that they're going to impose a three-line whip on something that is an issue of conscience.
Yeah, basically.
Well, it's good to see the Right Honourable Member's enthusiasm for reform of the House of Lords. It's a shame that he's only found it now that he is in opposition, and not over the last 14 years when his party was in government and could have done something about this. This was an immediate first step. This was an immediate first step as set out in our manifesto, and we have been clear that we will consult about the implementation of the other measures set out in our manifesto, and we will do just that. But we've heard a range of views today on the Government's other manifesto commitments, including exactly how a participation requirement might work. The debate has shown exactly why it is the right thing that the Government takes time to consider how best to implement the other commitments, whilst starting with the immediate reform that this bill will deliver. In conclusion, Madam Chair, the amendments tabled by Honourable and Right Honourable Members opposite are not appropriate for this bill, which deals with one principal issue: the need to remove the outdated and indefensible right of hereditary peers to sit and vote in the House of Lords. This is our objective, and we are focused on delivering it. The Government intends to deliver the other manifesto commitments to bring around a smaller and more active second chamber. It's also committed to replacing the other place with an alternative second chamber that is more representative of the regions and nations. As I've previously stated, we will consult on proposals seeking the input of the British public on how politics can best serve them. Madam Chair, reform of the House of Lords is long overdue and essential. The Government is committed to delivering those reforms, and the passage of this vital legislation is the first step on this journey. In that spirit, I commend this bill to the House.
The question is that Clause 1 stand part of the bill. As many of their opinions say aye. Vote for aye. Of the contrary, no. The ayes have it. The ayes have it. With the leave of the committee, I will put the question on clauses 2 and 3 standing part together. The question is that clause 2 and 3 stand part of the bill. As many of their opinions say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. I call Alex Burghart to move Amendment 25 to clause 4 formally.
We'll move formally.
The question is that Amendment 25 be made. As many of their opinions say aye. Aye. No. No. Question is that Amendment 25 be made formally. As many of that opinion say aye. Aye. Of the contrary, no. Tellers for the ayes are Jerome Mayhew and David Simmons, and the tellers for the no are Anna Turley and Anna McMahon.
98, the noes to the left 376.
The ayes were 98, the noes were 376. So the noes have it, the noes have it. Unlock. With the leave of the committee, I will put the question on clauses 4 and 5 standing part together. The question is that clause 4 and 5 stand part of the bill. As many that opinion say aye. Aye. Of the contrary, no. The ayes have it, the ayes have it. New clause 1 has been selected for a separate decision. I call Sir Gavin Williamson to move new clause 1 formally.
I to move formally.
Exclusion of bishops.
The question is that new clause 1 be read a second time. As many of their opinions say aye. Aye. Of the contrary, no. No. Division, clear the lobby. The question is new clause 1. As many of that opinion say aye. Of the contrary, no. The tellers for the ayes are Simon Hoare and Nick Timothy. The tellers for the noes are Anna Turley and Anna McMorrin.
41. The noes to the left, 378.
The ayes were 41. The noes were 378. So the noes have it. The noes have it. Unlock. New clause 7 has been selected for a separate decision. I call Sarah Olney to move new clause 7 formally.
I beg to move.
Duty to take forward proposals for democratic mandate for House of Lords.
The question is that new clause 7 be read a second time. As many of their opinions say aye. Aye. Of the contrary, no.
No!
Clear the lobby. That's right. Yeah. The question is new clause 7. As many of their opinions say aye. Aye. Contrary, no. The tellers for the ayes are Lee Dillon and Tessa Munt. The tellers for the no are Anna Turley and Anna McMorrin. Order.
Ayes to the right, 93. The noes to the left, 355.
The ayes were 93, the noes were 355, so the noes have it. Unlock. New clause 20 has been selected for separate decision. I call Alex Burghart to move new clause 20 formally.
Purpose of this Act.
The question is that new clause 20 be read a second time. As many of that opinion say aye. Aye. On the contrary, no. No. Commissioners, clear the lobby. The question is new clause 20. As many of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes are Jerome Mayhew and David Simmons, and the tellers for the noes are Anna Turley and Anna McMorris.
The ayes to the right, 98. The noes to the left, 375.
The ayes were 98, the noes were 375. So the noes have it, the noes have it. Unlock. The question is that I do report the bill to the House. As many of their opinions say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. Order, order. Order. Whip to report.
I beg to report that the committee has gone through the bill and directed me to report the same without amendment.
Under the order of 15th of October, we shall now move to third reading of the bill.
Now.
King's consent. Minister to move third reading. I call the Minister.
Thank you, Madam Deputy Speaker, and I want to thank honourable and right honourable members from both sides of the House for their scrutiny of this bill throughout its passage. I'm grateful to all those who contributed at committee, as well as those who contributed to the lively debate that we had at second reading last month. And I want to thank you and your colleagues for their chairmanship, Madam Deputy Speaker. I want to take the opportunity too to thank members on both sides for their contributions, in particular today, honourable and right honourable members from Stoke-on-Trent Central, Leeds South West and Morley, Stoke, Great Wyrley and Penkridge, Bolton West, Perth and Kinross-shire, Glenrothes and Mid-Fife, Bridgwater, South Holland and the Deepings, Alloa and Grangemouth, Gainsborough, South West Wiltshire, New Forest East and Dewsbury and Batley. And Madam Deputy Speaker, this bill is a matter of principle. It has been introduced to address an outdated and indefensible feature of our legislature, rather than any criticism of any contribution made by individual members. The Government has listened to the debate in this House with interest. I look forward to following the passage of this bill in the other place, where I'm sure there will be further thoughtful contributions. I want to thank my officials and the whole team who've worked on this bill. This House, Madam Deputy Speaker, will send the other place a bill that fulfils a manifesto commitment, and our manifesto on this was very clear. The next Labour government will bring about an immediate modernisation by introducing legislation to remove the right of hereditary peers to sit and vote in the House of Lords. That is precisely what this bill does. A clear and simple purpose, a single focus, and it completes a process that started a quarter of a century ago. It sends, Madam Deputy Speaker, a powerful message to people growing up in my constituency, in Blanavon, in Pontypool and Cumbran and beyond, right across the country, that you do not need to be born into certain families to make our laws. Now, Madam Deputy Speaker, when speaking at the third reading, this stage, of the Parliament Bill of 1911, that landmark reform of the House of Lords, on the 15th of May 1911, the then Prime Minister, Herbert Asquith, said this: "I repeat, as I began, that our first duty, in view of the electoral and parliamentary history of this measure, is to place this bill on the statute book. It is stamped, if ever a measure was stamped, with the authority and approval of the electorate of the United Kingdom. In that spirit, I commend this bill to the House."
The question is that the bill be now read a third time. I call the Shadow Minister, Alex Burghart.
Thank you very much, Madam Deputy Speaker. And I echo the words of the Paymaster General in thanking everyone who spoke in the debate this afternoon. It's been a good-natured debate and an interesting one. I just want to echo some of the words that were said by my right honourable friend from New Forest East in praise of the House of Lords, because when I first came to this place, I bumped into Lord Young of Cookham, who I'd known a few years previously, and I said, "How are you getting on in the upper house as a minister?" And he said, "It's rather harder there than it is down your end." And I asked him what he meant. And he said, "Well, you see, when I stood up as a minister in the House of Commons, I normally felt that with support of my officials, I was probably the best informed person in the room. But when you get to the Lords, you face 5 former Secretaries of State. You face 3 former heads of the civil service. You face people with expertise from across the sector. And what you find there is real scrutiny. And I love this place, I don't wish to take anything away from it, but I don't wish to see it replicated. One of us is enough. And that is why we have been pleased to see, despite the fact that we disagree with many of the things that the Labour government is doing, we've been pleased to see that they have edged away from their long-standing commitment to an elected upper house. An elected upper house would replicate this place unnecessarily. It would inevitably get in the way of the primacy of the Commons. It would inevitably make the passage of law harder. And, it was very significant that on the 5th of March, Lord Mandelson made an intervention with the Lord Speaker on his very popular podcast and said that Gordon Brown, the former Prime Minister's proposals for constitutional reform were barely put in the oven, let alone baked. And I'm very pleased to see that the Labour government has taken that on board. That said, this bill, in its presented form, cannot have the support of these benches. The Labour Party has reneged on the solemn promise that it made in 1998 not to get rid of the remaining hereditary peers until it brought forward a comprehensive plan for a reformed upper house. And the hereditary peers, who many members on the opposite side have tonight said sit there by duty of right, well, that's not entirely right. The reason why the remaining hereditary peers are in the House of Lords is because the Labour government put them there. That was the agreement that was reached in 1998. And those peers, those remaining hereditary peers, the ones who are already there, who already sit in the Lords, who night after night scrutinise the legislation brought forward by this House, who attend and play their role, should not be treated in this way. Had the government respected their position, had the government made provision for them in a reformed chamber, it would be very hard, not impossible, but very hard to oppose this legislation. But as it is, the government is seeking to remove established scrutineers in order to replace them with Labour appointees, and we cannot support it. The Minister's argument that these benches can nominate replacements is obviously not entirely genuine, because whilst we can put people forward, we cannot guarantee that they go into the upper house. The government could. The government could make that commitment tonight, but it has not done so. The government has said nothing about the 33 cross-bench hereditary peers that will be removed by this. Labour has broken its promise from 1998. It's broken its promise to bring forward all of its reforms immediately, and this party will not support it.
Simon Hall.
Thank you very much indeed, Madam Deputy Speaker. I will endeavour to be brief. This bill, I think, is actually to be welcomed. It is many things, but it is not, I fear, what the government has tried to dress it up as. It is the fulfilment of a manifesto commitment, but one made, as my honourable friend from the front bench has made clear, back in 1997. Blair blinked because my friend Robert Salisbury did what all Cecils have done since they were appointed by Queen Elizabeth. They did a bit of deal making and they found a solution. But if we listen very quietly, Madam Deputy Speaker, you can hear the voices of Labour radicals of the past muttering to themselves, is that it? Is that what all the years intervening between 1997, is that what 14 years of opposition navel-gazing as they contemplated the radical programme for government to remove 92 people that if Blair hadn't blinked would have been removed in 1998 in any event. No democratisation of the House of Lords at all. What a wasted opportunity, which I hope and know that our front bench will not replicate. What a wasted period of opposition that this timid church mouse of a bill, which has been brought forward to say, oh, we will take away some people who we would have taken away more than a quarter of a century ago. Now, the right honourable gentleman, who I can always consider one of the stars of the government bench, who is a good friend, told us that the principal motivation behind this bill is that the young voters and the young constituents of Torvine would say, there's a glass ceiling that has been removed. As if they have sat there thinking, I would love to get involved in public life if it wasn't for this roadblock to my advancement, namely 92 hereditary peers. Can I say, with the greatest of respect to the Treasury bench, I think that there's probably a greater percentage of the right honourable gentleman's constituents, as there will be of constituents of all members on the other side of the House, who are probably asking themselves, when will the Labour Party crash and break the glass ceiling of either being a person of colour or a woman to lead their party?
Pete Wishart.
Very grateful to you, Madam Deputy Speaker. Can I also congratulate the Paymaster General and his ministerial team for getting this bill through Parliament in such, as he's said on several occasions, with such a quick pace and doing it in such an early point in this parliamentary calendar. But I really hope that this isn't going to be it, because one thing the Conservatives have said is that this really is a timid pipsqueak of a bill. The Paymaster General quoted Herbert Asquith, and when he said several things about the House of Lords, but couldn't he have quoted Keir Hardie, when Keir Hardie pledged over 100 years ago to abolish the House of Lords? Couldn't he have quoted Gordon Brown, who only a few months ago said that they would be bringing forward a new democratically elected second chamber representing the nations and the regions of the whole of the United Kingdom? Instead, what we have is the low-hanging fruit of the hereditary peers. And isn't it remarkable, Madam Deputy Speaker, that it's taken to 2024 to remove the earls, the barons, the dukes, all the assorted aristocrats, and we have to give them great credit for doing this. This should have happened several centuries ago, far less in 2024. Now, I really hope that the backbench aren't going to be disappointed, because we've heard several contributions in the course of second reading again today in committee stage that further reform is going to be coming. This is the early and first stages of a whole package of reform that will be coming forward to this House. I have to say, we've heard it all before from successive governments, particularly Labour ones, who have promised successive reform to the House of Lords only for nothing to be delivered. So what we need to hear from the government front bench is when the further reforms are going to come. We need to have a clear roadmap to their ambitions when it comes to the House of Lords, and that has to start with ensuring that that circus down the corridor is properly reformed and we get to a position where it will be a democratically elected House. So well done getting this through. I really hope that they've not been sold a pup and that they will get the further reform that's been promised to them. But what we really need to hear from government just now is solid progress about proper reform to the House of Lords.
Right. The question is that the bill be now read a third time. As many of the opinions say aye. Aye. As the contrary, no. No. Well, the question is that the bill be read a third time. Are many of the opinions say aye? Aye. Of the contrary, no. No. Tellers for the ayes are Anna Turley and Anna McMorrin, and the tellers for the noes are Jerome Mayhew and David Simmons. Order, order.
The ayes to the right, 435. The noes to the left, 73.
The ayes were 435, the noes were 73. So the ayes have it, Unlock.